Wait, please, Lord. Beg to mention, my lord, item number 8, my lord. Now, I have been told, my lord, that diary is not available, my lord. My lord, have a can we have it on, my lord, Friday, my lord?
Yes.
17, my lord, not one. I am obliged, sir.
Wait. Wait, please, Your Lordship. It's a item number in regard to item number 37, the CD is not available.
37.
Not available.
CD not available.
Not available.
30? 37.
37, Lordship.
When?
Lordship, 17 or 20.
17 or 20 mile probably CD.
Kachar district.
Kasar district. On mile 21st mile. 20.
21st. Deep level.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 20, Your Lordship.
Hmm.
Lordship, the item may be adjourned for the day and fixed it on 16th, Your Lordship.
Who is in 19? You're praying for 20.
Yes, Your Lordship.
Just tagged with 19. CD is there.
CD not.
CD is not there. 20. But you should have consulted the counsel appearing for item number 19 because items are tagged together. Come back later on when it reaches after. The CD is not there anyway, we will probably have.
CD in the code number minus 3. Because in the last minus 9-7, it was vacation code minus. And CD was lying on the code number 3.
But matter,
Item 19 and
any connected matter is listed there.
Connected matter, same affair minus.
Okay.
Fine.
But CD is there in connection with another case.
Fine. No, minus. Same case was listed on the vacation code minus.
Okay.
Then thereafter it was fixed today.
So only we need to get the CD from
Fine.
there. Let it be called up because
Your Lordship, due
other
to-
counsel may have urgency. We do in item 19. Let it be called up first.
Yes, sir. Wait, please, Your Lordship. I beg to mention item number 17. A short date may be given, Lordship.
17 case diary received minus.
How short?
Maybe tomorrow or day after tomorrow.
17.
Day after.
17 to
Obliged.
Yes.
Praise the Lordship. Lordship, in item number 38, the petitioner has filed an additional affidavit yesterday. Lordship, that may kindly be called for, Lordship. Obliged, Lordship.
Yeah, please, Your Lordship. I beg to mention item number 31.
31 CD not received minus.
CD not received list again on
The order may be continued. Lordship.
interim order to continue. Give a date.
4th of August, interim is there.
Yes.
Please, Lordship. Lordship, I would like to mention item number 10, Lordship. I'm the informant in this case here also. We file a objection, come affidavit, Lordship. Kindly take the our affidavit with the main petitioner, bail petition.
Call for it.
Lordship, I beg to item number 10, Lordship, similar matter. The matter may be fixed on another date, Lordship. We'll file an additional affidavit also.
10.
10, yes.
What did he mention right
Yes,
now?
just now he has mentioned item number 10.
Date, Lordship.
You want another date?
Yes, Lordship.
All right. This is the matter again on so and so along with the additional affidavit said to have been filed by the informant. How many informants are there? All right. Yes.
Yes.
120 on Lordship.
Yes, on the CD is already available. CD
Okay.
On Lordship.
Mention that CD is received. Okay. CD receipt be retained.
Obliged.
May I please your lordship? Lordship, I beg to mention a bail application matter. The matter was listed yesterday, but as the matter was deferred, kindly fix the matter for tomorrow, your lordship.
What matter? You have to file a slip.
Also, we filed the additional affidavit in item number 54 supplementary list. Kindly take up the affidavit with matter 54. We filed a additional affidavit, lordship, in matter 54 supplementary list.
Yes.
If the requisitions, kindly affidavit in item 54.
All right, 54
Filed.
for the affidavit. Yes.
Also 48 can be taken up item 16 mil. 48 can be taken up item 16 mil. Same case there.
All right, with item 16.
Obliged.
Up to sometime.
Forty-nine.
49, lordship. Senior advocate Mr. S. Bortak will appear in this case, lordship. Appearing on his behalf.
This was earlier rejected, I think.
Yeah,
We'll have to call
earlier
for the
rejected.
CD anyway.
Yes, lordship.
Earlier rejected by your lordship on
It's been 41 days, lordship.
24/6/26.
We have annexed the earlier order along with this bill application.
All right, after some time.
After some time. Much obliged.
May I please, Your Lordship. Yesterday, I have received a copy of the affidavit in opposition. If there is record or not, I don't know.
It's probably not there in the record. We have filed it yesterday.
The issue is only with respect to the date of maintenance, whether it is from the date of order or it is from the date of application.
So what do you want now?
I have given that area amount has to be paid. Your Lordship will see the order dated 19/11/2025. 19/11/2000.
No, do you want this affidavit? It is not on record now. Do you want that on record?
Let that affidavit be on record tomorrow or day after the ship.
Is submitted,
Subject.
but an affidavit in opposition has been filed on behalf of the respondent. List the matter again. Day after tomorrow.
Day after tomorrow.
Yeah.
Obliged.
Obliged.
And for sole respondent also. Like I say, put of them and I, yes.
No stay is there. None appears. List again on. None appears for the appellant, Miss so and so appears for respondent. List again on.
Four.
Some of the first time when we admitted, madam. When you are punishment, madam, 304 part 2, madam.
Third. Bill against so and so. Bill is admitted. Call for the PCR. Private respondent is there.
Yes, madam, informant is there. madam.
Issue notice to the respondent number.
1-2, madam.
Steps by speed post within just list again on.
The date may figure 23/7, madam. Co-accused is on the same date, madam. On 23/7, madam. Obliged, madam.
Please, your lordship.
a regular bail application, section 6 of the POSCO is there. And for the informant, PROCEED has been engaged.
It is there,
My lord, scan copy is there, my lord.
translated.
Already search sheet has been filed and he is behind the bar since 255 days. The victim, the informant and the PW3 has been cross-examined, has been examined. For last 6 days, none of the witnesses are appearing. There are all totals 14 witnesses are there. FIR is at page 11.
Where is the deposition?
My lord, in the, I have flag mark, my lord, only victim statements, victim deposition is there, my lord. I have flag mark, my lord.
So what is there?
My lord.
Length of detention, lordship, maybe.
Length of detention, this length of detention will pale into insignificance.
Lordship.
But
Maybe consider the length of detention and any condition, lordship.
the nature of the offense,
My lord.
length of detention is not that much also.
Not on merit. I am not on merit. Just on length of detention. Any condition may be imposed.
Length of detention has also to be correlated with the offense.
My lord, and some of the vital witnesses are yet to be examined, my lord. That is.
Informant
that's what-
victim has already been examined.
Their statement is also not
There
available, my lord.
are 14 witnesses are there, and since last 6 days, none of the witnesses are appearing.
Why?
Not update, that is not update, my lord.
Huh?
In the record, it is not. update, my lord.
Yes, not.
And the positions of 2 and 3 are also not available. Only one is there.
Your goose is already cooked. Anyway, hard counsel for listener.
In the morning hour, T for was there, my lord. Yes, also.
An application under the allegation against the present petitioner is commission of penetrative sexual assault upon a 10-year-old girl who is his in the relationship of, who is in the relationship of granddaughter with him. The trial is already underway and the deposition of the victim has already been recorded. Tab full stop para having regard to the of the allegations and the material that has emerged so far. A fit case for grant of bail at this stage. Accordingly, the prayer for bail is rejected. TCR, scan copy of TCR received.
Oh, nice. Sorry to interfere, madam. Item 2, madam, my lord has fixed it on 4th of July, 4th of August. Let it be on 4th of August, madam. Only the non-appearance, that part. Item number 2, madam.
On the prayer of list.
I'm deeply obliged, madam. Deeply obliged.
May I please, Lord? My lord, here in this case, service report is waited, my lord. Service report is also better, my lord. I have taken steps thrice, my lord. Alene,
Item 5.
my lord.
He has taken fresh steps on Malad Kitty For vacation, he has taken fresh steps.
Comments on 36
Right.
after vacation commenced. So, should be ready by now.
I tried to get the instruction, but Malad till
Petitioner has taken fresh steps on 30/06/26 on respondent number 2. Learned additional PP to take instructions regarding service on respondent number 2. List
CD
again on
CD is available.
CD received, be retained. Next date.
Kindly have a short date, if possible.
17.
Ali.
May I please, your lordship? LCR was, TCR was called for in this case, lordship. There is the commercial quantity, my lord, court resented from the, my lord. But, TCR. Lordship will find in the production, it is in the, my lord, production skill. Commercial quantity, my lord, 21C, and none of the, this is charge not yet framed, my lord. And in the last occasion only, my lord, charge is submitted, my lord, and is in the production stage. I have taken 3 grounds, lordship, to this petition, lordship. May I submit from the FIR, lordship? We'll find the type copy of the FIR on page 23 and the original one on page 29, lordship. Lordship, here, lordship, article, my first ground is violation of article 22, lordship. Lordship, the petitioner were arrested on 18/4/26, which will be visible from the FIR, lordship. It's the date and time of apprehension is there, lordship, in the FIR itself.
Yes.
With reference to the subject cited above, I have the honor to report that today, that is 18/4/26, I along with so and so of Gauhati's ERPS were engaged on platform patrolling duty.
Alright, you don't have to read entire affair.
Reading the time, lordship. 8:40 AM they were been apprehended, lordship. And it is written in the down below that they were apprehended, lordship. And accordingly, the suspected contraband, which is heroin, lordship, has been seized with 2 separate seizure lists from both the petitioner, Lordship. From one petitioner, 165 gram, and from the second petitioner, 153 gram.
Yes, then
Then they were produced on 19/4/26, Lordship. That is after 1 p.m. Lordship, and that Lordship will find on page 44 the medical records which are been the medical examination which are done prior to the production of the accused, and which is reflected also in the production order, Lordship. The production order, in the production order, the concerned magistrate had gone through the medical records, and the time of the medical is reflected in page 44 and page 45 of both the petitioner, Lordship. The date and time is 19/4/26, that is 12:23 p.m. and other petitioner is 19/4/26, 12:26 p.m. They were produced after 1 p.m. Lordship. They have to be produced on 18/4/26. Their apprehension time is 8:40 a.m. Lordship. Time of apprehension is 8:40 a.m. Lordship.
that is one ground. Then
Ground, Lordship, Lordship has already made observation, Lordship. In arrest memo, Lordship may come to the arrest memo, Lordship. On page 46, from page 46, the arrest memo of both the petitioners starts, Lordship.
yes,
Lordship may kindly come to page 47. Arrest memo requires a independent witness, Lordship. And in that regard, Lordship has made observation in a similar NDPS case, Lordship. Lordship, the witness is a police personnel, Lordship, not an independent witness, Lordship. In both the petitioner's arrest memo, Lordship will find a police personnel who has signed as a witness, Lordship. Lordship, I have submitted a few observations made by this honorable court, Lordship. Lordship, in BA.
so that is your second ground, no signature of
Yes.
witness.
Yes.
Third
have-
ground,
Other ground, Lordship, Lordship may kindly come to one of my, I have submitted a order, Lordship, bail order of coordinate bench, Lordship.
first state the ground.
Lordship, the individual quantity of both the petitioner falls under intermediate quantity, Lordship. And in that regard, a coordinate bench has made an observation, Lordship. In BA 2040, Lordship, I have submitted the order, Lordship. Lordship may come to page 2 of the coordinate bench observation, Lordship. BA 2040, Lordship. Lordship has found, Lordship. From one petitioner, 165 gram, and from one petitioner, 153 gram was seized, Lordship. 250 gram is the 250 fall under, below 250 would fall under intermediate quantity, Lordship. They have already been custody since 18/4/26, more than 60 days, Lordship.
Where is this decision?
Lordship,
Amar Singh,
yes, Lordship.
Where has it been held that it has to be
I have not
considered
found the
individually?
specific- I have not found the specific para in Amar Singh, which has been quoted in the order of coordinate bench lordship. But the coordinate bench has observed that particular.
So should we now go to the coordinate bench and ask, where did you find it?
I have not found the specific para. But the observation was there, lordship.
Yes, PP.
My lord, here, my lord, he has pointed out three, my lord, grounds, my lord. One is he has FIR and F3NZ, my lord, and as per my lord, FIR filed on 18/4/2026, they were caught red-handed, and thereafter they detained, my lord, and formally it was arrest is defined, my lord, apprehension and formally arrest is defined, my lord, and from the medical report, it reveals that if medical examination, my lord, it reveals that they were produced on, my lord, 19/4 at 12:30. It was examined at 12:30, my lord. And formal, there are some procedures, my lord. After detaining, my lord, some procedures are there, my lord, that are conducted as per, my lord, law. And within 24 hours, they were produced before the, my lord, magistrate, my lord. And regarding second point, my lord, arrest memo, my lord, 36. Here, there in the coordinate benefit, my lord, some contradictions were there, my lord, regarding the 36 arrest memo, my lord. And that's why the Honorable Justice Pranjal Das, my lord, it was sent to the Chief and Chief Justice for larger bench, my lord, to decide the matter regarding the 36, my lord. And
No, I'm not getting you. Here his ground is that the no signature is
my
there.
lord, that was, my lord, some of the, my lord, coordinate bench, it was when there is a, my lord, some said that, my lord, there is no need for 36, when there is a 48 notice is there, my lord. On that contradiction, some coordinate bench, my lord, passed some judgment in favor of them. Some of them passed in favor of us, my lord. Thereafter, it was sent to them. It was placed before, my lord, Pranjal Das, my lord, Justice Pranjal Das, and Lordship was pleased to send it to the Chief Justice for larger bench, my lord, to decide the matter, my lord. Regarding 36. 36 is different, lordship, and lordship has already made an observation in BA 6/26. I have submitted, lordship. It was, my lord, some this where lordship has arguments were done on para 6, lordship has stated furthermore a perusal of arrest memo. 1239 of 20. My lordship, BA 1239 of 26, my lord. Has sent. BA 6, I have submitted, lordship. 26.
Yeah, that is okay. In that case, the 48 notice was served
mine,
containing the grounds and everything.
Mine.
Where is your 48 notice here? Even if you seek to take advantage of that judgment.
My lord. আমি annex করা নাই 48. No, 48 most probably served. Forwarding to Marcelo. Probably the 48 in this case also not served, lord.
Okay, you check.
My lord, here it is, my lord, page 39, my lord. Meta may fiction day after tomorrow, my lord. I'll go through record again, my lord. Page 39, it was, my lord, enclosures. Page 39, my lord. WTO 49. Enclosures, last portion, my lord.
But it's not enclosed here.
In my application, it's not.
Yes.
That is all.
So find out where that is. It's a bulky file. I don't have to go through all of it.
Any other day? Lordship at 2 p.m. No, today is not. At 2 p.m. lordship time. My lord.
Any other date?
The 48 will be there, lordship. It did not take much time finding out, lordship. 2 p.m. lordship time.
Well, if he can, he can. If he cannot, then
Tomorrow, bye.
all right, tomorrow.
Tomorrow.
Please again on so as to enable learned additional PP to go through the records.
Deeply obliged.
The 7 and 34 are connected meters. CD is not available. I am already on interim bail.
Not received.
CD not received, my lord.
Give a date.
On my lord, 5th of August.
Both cases interim is there.
Yes, your lordship. 7 and 34.
Somebody else is there or you were there.
Yes, man. My
Your-
name is there, reflected in the vakal. DK Agarwala.
Give a date. See interim to continue.
Grateful minutes.
First, check if the interim is there, okay? Because one is a bail application, other is.
May I please, Lordship? My lord, this is bail application, my lord. Petitioner was arrested, my lord, on my lord 9/5/2026, my lord. Today is my lord 67 days, my lord. My lord, FIR is my lord phase 11, my lord, of party portion of the FIR. Regarding my lord fake currency, my lord.
Yes, what is your ground?
My lord, my ground, my lord, I have stated paragraph 5, my lord. Actually, what happened, my lord, I was coming, my lord, to Guwahati, my lord, from Nogao, my lord, and dropped at my lord, Khanapara bus stop. And thereafter, my lord, I went for defecate, my lord, keeping my bag in the tea stall, my lord. And immediately after, my lord, come back, my lord, the police, my lord, seized my bag and my lord, purportedly recovered, my lord, the seized item, my lord. My lord, not my lord, recovered from my bag, my lord.
So you claim that the bag was yours, you admit.
My lord, bag is mine, my lord.
Only
My
your.
lord, my lord, my bag, my lord, I am, my lord, I went for defecate, my lord, keeping the bag inside the tea stall, my lord. And immediately after returning, my lord, to the tea stall, my lord, subsequently, my lord, the police, my
So
lord,
you have been framed according to you. Somebody put it there.
my lord, as per my allegation, my lord,
Who are you?
my lord, I am a driver, my lord.
Not leader of the opposition.
No, my lord.
So you are such a big man that police just wanted to frame you by putting FICN there.
67 days, my lord, custody, my lord, my lord. Further custodial interrogation is not.
Yes.
A huge quantity of fake currency note recovered from his possession, my lord. 1760 pieces, my lord. Total 23 bundles, my lord. Value is more than 8 lakh, my lord, 8,80,000. So length of detention cannot be a ground, my lord. These are economic offences.
Petitioner is the sole bread earner of the family, my lord.
I think he has earned enough bread by now to sustain you for several years.
During the my lord, detention period, my lord,
I'd learned counsel for the petitioner. Is an application under suspension. As part of
earlier occasion, my lord, petitioner approached before the learned trial court, my lord,
allegations.
was also rejected, my lord.
Page 12, okay. Submitted on behalf of the petitioner that he was traveling in a night super bus and had got down at Khanapara and had kept the bag at a tea stall, his bag at a tea stall, to answer the call of nature. However, the police seized the said bag and recovered the aforesaid fake currency, about which the petitioner had no knowledge. He submitted that somebody else had put in the fake currency in his bag. Para. The aforesaid explanation appears to be plausible, as no reason has been shown as to why someone else would seek to implicate the petitioner, who is a driver by profession. Para, having regard to the material available in the CD, also to the fact that the alleged offense poses a threat to the economy of the country, and hence the offense has to be regarded as one of a serious nature, the prayer for bail stands rejected at this stage, notwithstanding the length of detention of 67 days. Petition stands dismissed. Send back the CD.
Well, 11 may kindly be passable for the time being, well, scan copy is there, so I will.
That's small issue, my lord. I'll just explain, my lord. There's not much, my lord, in this can.
We'll again go back to the same thing, even after you explain.
After some time.
After some time, let it be.
Please, your lordship. Also, item number 12 and item number 13 arising out of same FIR, lordship.
Yeah, please.
The allegation herein is 3104 of BNS and read with section 30 of Arms Act. 3104, lordship, is preparation for Gauhati, and section 30 of Arms Act is there. Lordship, in item number 12 and 13, from petitioner of item number 12, the arms was seized, lordship. Lordship, FIR is on page 17, lordship. While the present petitioner, along with some other person, lordship, while they were sitting at a restaurant, lordship, from the possession of present petitioner of item number 12, arms was seized, which he has a license, and present petitioner is also a retired person from CRPF, lordship. And not only the arms, the present petitioner, from the possession of present petitioner, one Gorkha Khuri, one hand force butcher knife, one multi-T cutter, 3 keypad mobile phones, these were seized, lordship. Allegation is of preparation of Gauhati, lordship. Basically on suspicion, and this is like preventive arrest, lordship. The police has not, police has only mentioned the prepare, they have implicated the section, but they have not mentioned where and when.
Item number 12 is who? This
Item-
Monu Basumotari.
Monu Basumotari, from whose possession the alleged
Yes.
articles were seized. And
What was seized? .32 MK2.
yes, gun, which he has a valid license, lordship. Lordship, we have annexed the license also, lordship, on page 36, lordship.
So dacoity cannot be committed with a license down.
Lordship, the investigating agency has mentioned that allegation has been there, preparation of Gauhati, but police has not mentioned where and when and whose house Gauhati will be committed. It's basically like a preventive arrest, Lordship. And this, both the petitioner are retired person from CRPF, Lordship. I have annexed their IDs, Lordship. Page 37, Lordship. And other thing which were been seized from both the petitioner's possession, that are knives and other things, Lordship. They were, at that time, they were at a hotel, Lordship.
What is the stage of the investigation
The
now?
investigation is still going on, my lord, regarding because some retired, these are retired CRPF personnel and one retired BSF personnel, my lord. Initially, 3 persons arrested, my lord. And later on, my lord, item number 13, Dilip Sorgiari, my lord, on the basis of their statement, my lord, Dilip Sorgiari was arrested, and according to them, my lord, Dilip Sorgiari is the main person who is involved in, my lord, conspiring the entire offense, my lord. They, not only those, my lord, the pistols were recovered from the other sharp weapons also recovered. And my lord, black colored dress and neck marks were also recovered from them. Black colored dress and neck marks were also recovered, my lord.
Mask.
Marks, my lord. Clearly intended to conceal for concealing their identity and other, my lord, sharp weapons, my lord. Kukuri and knife, multi cutter, my lord, and
I think we have seen this affair before.
Lordship has, before vacation, Lordship, it has came before this, before Honorable.
CD was not there.
Yes.
on the
It was
basis
not
of,
there, Lord.
on the basis of
On the motion
specific
stage, Lord.
information that some persons gathered for committing dacoity, my lord. Thereafter, on the basis of that
Already
information, police searched that
The target, he is the informant, I think. One person lost the.
Complainant is police personnel. Lord.
police person.
And 45 days already petitioners are behind the bar, 60 days offense, Lordship. The seizure witness probably have been recorded, Lordship, as seizure list has been made, Lordship. It will be a matter of trial, Lordship. As
So what remains for investigation now?
My lord, that's because those are my lord retired CRPF personnel and some other personnel may also be involved regarding.
No, but they are in judicial custody now.
Yes,
You have not sought their interrogation again.
no
It
criminal
had
antecedent.
learned counsel for the petitioner and decision application and so and so. Page 25, in brief facts of the case. Learned counsel for the petitioner submits that the petitioner is a retired CRPF
CRPF, Lordship.
personnel and the
Number to BSF. So item number 12 is a CRPF and item number 13 is BSF.
we are on 12. Okay. That the pistol that was recovered from him is a licensed one. The license has also been annexed to the instant bail application. On the other hand, learned additional PPC that besides the pistol, other objectionable items like kukri, etc., including mask and black colored dress were recovered, showing, indicating that petitioner along with others were preparing to commit dacoity. Para, the CDS called for has been received. It appears therefrom that the investigation has progressed. And by now, the spent 45 days custody during the above, the therefore bail is allowed. 2002 securities. item number 13. And that license or he does, arm was not recovered from him.
Not recovered from him. He was arrested upon the statement of Manu Basumatal.
His license part 2, he took a then submitted. The petitioner was arrested on the basis of statement of co-accused and no arms were recovered from him. Full stop. So to develop besides the pistol recovered from co-accused. মিলাই দিম পিছত।
Deeply obliged.
May I please? This is a regular bail application, my lord. Petitioner, he was a government servant, my lord. Now suspended. Now he was arrested, my lord, with the allegation that he was being trapped while he accepting the bribe, my lord. So it's basically trap case, my lord. He is already behind the bar for more than
55 days today.
today, 55 days, my lord. 60 days is the mandatory period. And lordship knows, my lord, in these kind of cases, when the trap is laid down and the trap is successful, the investigation more or less 90% is already been completed because the pro-step and the pre-step memorandum has to be completed on the day itself when the trap is being completed, my lord, along with the post-step memo. In this case also, post-step, pre-step has been completed on the day itself. Nothing remains, only the voice recording that also been completed. I am 55 days, only a period of detention, my lord. There is nothing, my lord. It is there's some recovery, my lord. For that, in my house, there's a further allegation that the some amount has been recovered subsequently. For that, my lord, I'll face the disproportionate charges, my lord. That's initially that will be a different proceeding because lordship knows for the disproportionate asset case, my lord, there has to be there is a preliminary inquiry. If I fail to satisfy the authority, then there will be a regular investigation and subsequently there will be a case. So this is the procedure, my lord. And this case, my lord, already the investigation is more or less completed. No further investigation, no interrogation in the judicial custody. Initially, I was more than
Where is the
my lord.
where is the FIR?
My lord, FIR at page, my lord,
17.
17. That's the type copy, my lord.
Yes, PP.
My lord, here the petitioner, my lord, petitioner was the additional secretary to the government of Assam, my lord, Revenue and Disaster Department, and also additionally holding the post of, my lord, additional director, Directorate of Land Records and Surveys. And my lord, for clearance of a, my lord, land sale permission, he demanded an amount of rupees 1 lakh from the, my lord, victim. Thereafter, my lord, my lord, the informant lodged an affair before the, my lord, SCB police station, and on the basis of thereafter, my lord, his voice, my lord, during, my lord, that, my lord, demand later on, my lord, he negotiated at an amount of rupees 50,000. And the conversation between the, my lord, accused person and the informant, those voice recordings were recorded in a, my lord, voice recording device. And thereafter, my lord, after lodging the, my lord, that
No,
FIR,
no,
my
that
lord,
part we have seen. What is your
yes.
reply to the submission?
Now regarding the, my lord, that from the, my lord, present petitioner, my lord, 48 lakhs, my lord, 38,015 rupees initially recovered. Thereafter, again, my lord, case amount of rupees 1 crore 18 lakhs 30,000 recovered, my lord. And being, my lord, holding such a, my lord, high level post, my lord, from a, my lord, for clearance of the land sale permission, my lord, he has demanded such a, in fact, my lord, those, my lord, voice recording conversation were also there in the CD, my lord. What were the conversation between the informant and the accused persons, my lord, and how he demanded that amount, my lord, being holding such a, my lord, high level post, my lord. Thereafter, my lord, negotiated that amount to an amount of rupees 50,000. He not only demanded, he also accepted, my lord, that amount. So considering all this aspect, my lord, thereafter, my lord, under section 7 of the, my lord, of the PC Act, my lord, case has been registered against the accused, my lord, and there are sufficient materials, my lord, against while holding such a, my lord, high level post, my lord, in this type of cases, my prayer before your lordship, my lord, he has taken, my lord, undue advantage of his position and demanded an amount of rupees, huge amount of rupees, 1 lakh, not only demanded, my lord, also accepted. So my prayer before your lordship that considering that all these aspects, my lord, CD from the case diary, my lord, and from the materials available on record, on the ground of length of detention also, my lord, petitioner is not entitled for let this.
Length of detention always my lordship can always consider the nature of the investigation. Here the nature of the investigation, already been completed, my lord. They said the voice has also been, that has been testified also. Everything is completed, post-tape, pre-tape. I am on 55 days in custody. Next 5 days I'm 60 days is the mandatory period. Regarding the recovery, my lord, there is another case has already been registered, that is ACB 22, my lord. ACB under this section 13. That's a different proceeding, my lord, no way connected to. That's a disproportionate asset. I'll face that consequence in that case, but this is a case of only 45,000 recovered from the alleged, but that's a case of disputed, my lord. I'm not going into that merit, whether it has been recovered from me. It was recovered from a bag kept under the table when I was not there. Subsequently, it was recovered. That's a matter of dispute, my lord. We'll see. For their document, it is apparent how it has been recovered. It was not recovered from my hand. From their forwarding, it is apparent. But that's a matter of trial. I'm not going to dispute at this stage. Even I don't want to actually divulge this, because their document itself, tainted money recovered from the black color handbag under the table of the floor, not from his hand. Their own document in the page 27A, the forwarding report. I'm not on that, my lord. Basically, though he says that it was recovered, except demand and acceptance. Acceptance is different thing, my lord. There may be demand, and that day there is no demand, just previous demand. Whatever that may be, my lord. And the recovery, my lord, always disputed. That is a matter of trial. They cannot dispute this part also, which is in the forwarding report already. But I am on the, what is the purpose, my lord, of detaining me, my lord? I'm already been suspended. Everything you have recorded, investigation is completed. No search sheet till 55 days.
45 or 55?
55. Generally, these kind of cases, my lord.
From the CD, can you say it can be filed within the next 5 days?
My lord, although, my lord, regarding that aspect, my lord, it is difficult for me to say anything, but considering these aspects, while the
Even then, my
petitioner
lord,
is
already, my lord, when the
high level
investigation is
proof and
completed.
regarding, my lord, in presence of independent witnesses, those.
I said I'm not on that, but
And
there
not
I am on
thereafter,
their document itself.
huge amount of case,
Yes,
more
yes.
than 48 lakhs.
But that's a
thereafter
different
more than
case.
18 lakhs, my lord. Those, my lord, amount.
That's a different case, my lord. I'm not saying that you have
During the
already registered a
investigation of the
case, my lord.
present case, my lord, those, my lord, amounts.
ACB 22, you have not disclosed it. ACB 22
ACB
already, I said.
22, that is, my lord, disproportionate case. That case was also registered against.
That is what I'm saying, my lord.
During investigation, my lord, after, my lord, apprehending the accused.
This is a case we have to consider.
There will be a separate trial.
There'll be separate trial, everything separate.
Regarding the voice conversation, that audio recording, my lord, what was the conversation between the informant and the?
I have admitted, my lord.
My lord, regarding detailed conversation is.
I have
there is
admitted at this stage.
Still,
That's,
let me
these
tell
are
you
all
the
matter of
process.
trial. I'm on the period of detention. And what is the kind of cases? These are the kind of cases where the investigation is completed. What is the purpose of detaining me?
I will hand over the case diary, my lord. CD is.
What is the purpose of detaining me, my lord?
All right, hand over the CD.
Yes.
Publish.
Publish.
May please, Lordship. But the petitioner is 32 days behind the bar, my lord. Cross FIR is there.
My lord, 15 in this case, charge sheet submitted, my lord.
Already similarly situated another FIR, cross FIR case. One petitioner was released on bail, Your Honor.
In the present case, my lord,
Allegation, both allegations are
145/26, charge sheet submitted, my lord.
Allegations are same, my lord. Similarly situated person, and both are neighbor, my lord. Husband of the Zahar Kari already released on bail. When in the cross FIR, husband of the cross FIR Kari, he is in the jail. And for him, that present application was filed, my lord, for enlarge him to go on bail, my lord. May I read the my lord?
What is your name?
My name is, my lord,
That
Azmov.
earlier person is Alimuddin.
Alias or Alimuddin.
Now, this one is
This one is Azmol, my lord.
Azmal.
Azmol, my lord. Both are allegations, both in the both FIR, my lord, are same, my lord.
So this relates to the same FIR.
Other FIR, my lord. Cross FIR. In the second FIR, my lord, page number 14, my lord, annexure 3. And here,
That is the FIR lodged by the wife of Alimuddin.
my lord, my lord.
In
my
the
lord.
present case.
Present case, my lord.
So both the petitioner, in two cases, two petitioners,
My lord.
Alimuddin and this fellow.
My lord.
And both your wives have made allegations against each other's husband.
Each other husband, my lord. And allegation also that he give the signal about 6 months ago, and in the second FIR, signal have given 1.5 years ago. And both the neighbors, both the a main source, my lord, land dispute. And
Yes, how many days?
it's 32 days, my lord. And Alimuddin released on bail on 14 days, my lord.
Third learned counsel for the petitioner and learned 15. CD is received, is it?
No, my lord, I have only received the instruction regarding filing of charge sheet.
CD as called for has not been received. As per the allegations made in the FIR, the petitioner had made suggestions to the informant lady, who is a married woman, to get involved in physical relationship, which was rejected by the informant, whereafter the accused tortured her in various ways, threatened to kill her and her family members. It appears that The wife of the present petitioner had also lodged FIR against the husband of the informant, making similar allegations. And the said husband, namely one Alimuddin, was granted bail by this court by order dated 26/6/26 in PA 1778 of 26. Where the petitioner has in the meantime spent about 32 days in custody. Where having regard to the period of detention as well as the nature of the allegations, further detention of the petitioner is not considered necessary. 50,000 to see it.
Leave Lovelace. Leave Lovelace.
Yeah, my lord, with all respect, my lord, in Sribhumi jail, I lead the FIR, my lord. Sribhumi jail, my lord. There, what has happened, my lord, jail officials, allegations, my lord, with all respect, my lord, they provided primarily, my lord, the case is that mobile phones were provided to the, my lord, inmates, my lord, meaning thereby accused or convicts, my lord, in lieu of money, my lord. Monthly, some payments were taken, 3,000, 5,000, and mobile phones were given, my lord. Now here, so far as this accused is concerned, my lord, in the FIR, his name is not there, my lord. And in the forwarding report, his own forwarding report, my lord, because statement of co-accused, my lord, the accused persons who were arrested, my lord, inmates, my lord, either accused or convict, my lord, who use mobile phones on payment of money, my lord. On their statement also, my lord, in the forwarding report, with all respect, my lord, because it's an omnibus statement that jail officials were paid money. My lord, his name is missing, my lord. Let me come to that, my lord. And today is, my lord, 27 days, my lord. 37 days, I'm sorry, my lord. 37 days. Lordship would kindly have a look at the FIR, that is page 18, my lord. If I read it in total, my lord, if I read it, my lord, one paragraph is important, my lord. First paragraph, second, third paragraph, my lord. Further, as per Assam Prison Act, lordship may have found, my lord. Further, as per Assam Prison Act 2013, page 18, my lord. Item 48, my lord. I'm sorry, my lord, item 48, my lord. Two items are together, my lord. Same case diary.
16 and 48.
My lord. I'm reading from 48, my lord. 48 to
Biswajit.
Yes, my lord. There, lordship would kindly have a look at page 18.
Yes.
Page 18, my lord. First paragraph, second paragraph, third paragraph, fourth paragraph, my lord. Further, as per Assam Prison Act 2013, my lord. Lordship may have found, my lord.
Yes.
A prisoner is strictly prohibited from using communication device, goes on and on thereafter. It is also suspected that the entire matter has the connivance of some members of the district jail authority and security personnel, since the UTPs of convicted individuals were carrying on their criminal activity within the jail premises with the campus under round-the-clock security. This much is there in the FIR, my lord. Names are not there. And the forwarding report, my lord. Thereafter, my lord, prior to the forwarding report, my lord, I'm coming to page 20, my lord.
Dated 10th of March.
Then 7 was attributed, my lord. 7 of the PC Act, my lord. By this, I'm putting emphasis, my lord. 7 was attributed by this page, my lord, page 20. And this is dated 10/3/2026, my lord.
3 months before
This was attributed, my lord, on 10/3/26. We are not arrested, my lord. The 35/3, my lord. On that point also, my lord, on that count also, my lord.
Because this is maybe goes.
Upon notice we appear, no new materials because that the latest authority, my lord. Apart from that, my lord, here, my lord, kindly see, my lord, while aiding, my lord,
8th line.
8th line, my lord. Last paragraph. During the interrogation of the shown arrested accused persons, the inmates who were using mobile phones, they were arrested, my lord. Accused or convicts, my lord, stated that they got mobile phone to the jail warden, Subhasis goes on and on, my lord. My name is also there, Kuntu.
They used to play by.
Naam to ko.
Rudra Deuri and
No, my lord. My name is there, Biswajit Deuri, here, my lord. While aiding, my lord, Biswajit Borwa, Lordship may have found, my lord.
Yes.
But payments were not made to him directly. Last line, my lord. On the basis of 3,000, 5,000, 10,000 per month basis, one time for using mobile phone inside the jails, and they used to make monthly payment through jail warden Subhasis Ghosh. Have I made my position clear, my lord? The inmates who were using mobile phones were paying directly money to this character, my lord, jail warden. And from him, allegedly, another link, my lord, with all respect, my lord, that it was paid to the present accused before your lordships also, my lord. This is it, my lord. And this was added on the 10th of March, my lord. 10/3/2026, thereafter, my lord.
Forwarding report. Page 23.
Forwarding report, page 23, my lord. Arrest possibly is redundant. Grounds of arrest, my lord, of the present accused. Upon interrogation of all the arrested persons who were using mobile phones, my lord, cell phones, now they came to conclusion grounds of arrest, my lord, 6. Lordship may have found, my lord.
Yes.
Accused inmates, namely so-and-so, 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 who were arrested earlier, my lord, have consistently named jail warden Subhasis Ghosh, that name person named in a forwarding report, my lord. Subhasis Ghosh, assistant jailer Rudra Deuri, and Jamadar Murshid Ali as facilitators for smuggling and providing mobile phones inside the den in exchange of money. My name is missing, my lord. This is the forwarding report by which I was placed before the learned court below, my lord, upon the production on the first date, my lord.
And all the rest allegation are omnibus.
The rest of the allegations are omnibus, my lord. And primarily money was paid by the inmates, my lord, not to this accused or any other accused, my lord, but to, my lord, with all respect, my lord,
Warden.
the warden, my lord, who is named, my lord. And I am there for 37 days, my lord. And another aspect, my lord, of course, may not be necessary, but I am placing, my lord.
Page 37.
Page 37, my lord.
35 notice.
35 pre-notice, my lord.
2626.
Date is 2626, my lord. 3 months subsequent to adding, my lord, that I read out, my lord.
No new ground.
With all respect, my lord.
7.
My lord.
After reading 7.
Yeah, after adding 7, my lord. After 3 months, I was arrested. And, my lord, no new grounds, my lord. So, my lord, even 35(3), my lord.
They cannot arrest.
They cannot arrest, my lord, violations, my lord. They are, my lord, 30, my lord, with all respect, my lord. Until late, my lord, with all respect, my lord, 2026, my lord. 30, my lord, paragraph. May I read, my lord?
Yes.
May I read, my lord?
Yes.
While making an arrest under section 35(6) of the BNSS, meaning thereby after calling and after appearing, my lord, this procedure was carried out, my lord, in 2023 after the stage of issuing a notice seeking presence under section 35(3) of the BNSS, 2023, the circumstances and factors that were in existence at the time of issuing the said notice, first notice meaning thereby, my lord, we appeared, shall not be taken into consideration by a police officer while making an arrest subsequently. In other words, for effecting an arrest under section 35(6) of the BNSS, It must be based upon materials and factors which were not available while the police officer at the time of issuing a notice under section 35(3) of the BNSS 23.
10th of March for materials.
10th of March, all these materials were before the police, my lord. 10th of March, when we were called. Thereafter, on the date of arrest also, my lord, with all respect, my lord, the same materials, my lord. Therefore, the power of arrest under section 35(6) of the BNSS 23 is to be exercised rather sparingly only under circumstances as aforementioned, meaning thereby no new material, because statement of the co-accused, which came to light way back when 7 was added, that is 3 months back, and the date is
10th of March.
10th of March, my lord.
Checklist came from the West.
And checklist also the same grounds of arrest by page 39, my lord.
Nothing new.
Nothing new, my lord. Checklist, it is at, my lord, within, my lord, page 39, my lord. On that count, it goes, my lord.
How many days now?
37 days.
Earlier rejection was a.
Earlier, anticipated bail was rejected by your lordships, my lord.
Yes, PP.
Yes, firstly, I wanted to state that lordship. The item number 16 lordship, it was earlier rejected on the ground that there are available incriminating materials against the petitioner lordship. However, these two petitioners, Rudra Deuri and the Biswajit Borua, they are in a responsible position lordship. They are the assistant jailer of that jail lordship. Moreover, one of the things I want to point it out that the jailer himself stated that the statement of the jailer, he stated that on 2/2/2026, his sanction lived. His leave has been sanctioned. The accused Rudra Deuri was the officer in charge of on that day. Firstly, I want to point out that lordship. Secondly,
I am Biswajit Borua, my lord.
Biswajit Borua, I am talking about Rudra lordship. First, sorry,
my lord.
As it is 16 lordship, I am talking about that.
Who is for him?
Item number 16.
Who is appearing for 16? You are.
Rudra Deuri. So he was in charge at that point of time, lordship. Moreover, I also wanted to point out that lordship 61(2) is there. So criminal conspiracy is there, and lordship very well known that in criminal conspiracy, what role is played by what, it is not important. It is a conspiracy, lordship. And if I look into the statements of the inmates, lordship, they have clearly stated that they wanted to communicate with the family members, and in that thing, lordship, this jailer Rudra Devi and this Biswajit lordship Borua or Biswajit lordship, another jailer Biswajit Borua, another jailer, they were trying to help these two persons lordship. They give phones, and it is quite evident lordship, they will not take money by themselves. Why they took money by lordship and warden? They took money and give it to the jailers, lordship, assistant jailers. And it has been clearly stated that all these two persons, they know that they are being given, provided with the phones, lordship. Again, I again wanted to point out that, lordship, again, there is an inquiry, inquiry report is also there, departmental inquiry report. It has been found after looking all the things, lordship, all the witnesses and other things, lordship, they have been quietly represented, and it has been found that they have been, lordship.
Are they given phones permanently that you?
Lordship, there is a thing. If I look into the complainant statement, the SI who first lodged the FIR, he stated something, lordship. He has stated that he has an information that the inmates of the jail, lordship, were trying to escape from that jail, and they have communicating with other people's, lordship. And in that regard, while conducting investigation in that regard, they have found this mobile, lordship. And moreover, on the top of it, lordship, there is another thing is there.
These two persons, what they do, then one intermediary person is there, Lordship, who is in hospital also, Lordship. They talk to first this person. Communication, that CDR is there, Lordship. They talk to this person and they in return talk to this accused persons. And one name is also there. I will not want to mention it. It is investigation is going on. One of the inmates has been communicating with all this person. So investigation going in on the different lines. On that inquiry is also there. Why they are communicating with this person's, Lordship? These intermediaries also need to be there. Again, another thing, Lordship, the CCTV of this jail, Lordship. This person, the Rudra, he was working there since 2024. And from 2024, the CCTV is not working. He has not communicated to anything. He has not communicated about this thing. This is also there. SP has also given to that, Lordship. And moreover, now the investigation is going on regarding the bank details. 2025 to 2026. It is pending, Lordship. So, Biswajit Borua, against this person also, the inmates have stated that all these persons are there. So, I want to point focus on the thing that, Lordship, it is earlier rejected on the ground of materials, Lordship, and this is a very serious issue, Lordship. What things are going on? They are the inmates. Inmates are having 29 seizure is there. These two persons are the witnesses, Lordship. How it can be, Lordship? These persons are there. They have been strict, Lordship. Security is there. These are the responsible persons are there. How they cannot locate these things, Lordship? So, Lordship, it is a very serious matter, and very materials are sufficient materials are against both these persons. However, this Rudra Deuri, against him, I am stating that all these things are there. CCTV is not working, but I have not found any letter that they have informed to the higher authorities. Nothing is there. So I rest that, Lordship. There is a 61(2) is there. So what role they play, whether they have been directly taken the money or not, it is a different thing, Lordship. It is a matter of trial, and there is a criminal conspiracy. They will not take money directly, Lordship.
Nodal officer is there.
No, Lordship.
Regarding his submission with regard to section 36.
Regarding 36, Lordship, he has been given the 30, regarding 36, Lordship, what his signature is there in arrest memo. Signature is there of the
No,
witness.
that is not the ground he has raised.
Lordship.
Yes, first they were called by issuing notice.
Lordship.
For that they were arrested,
Lordship.
but they were arrested on pre-existing grounds, the grounds on which the notices were issued.
Lordship.
No new ground has been unearthed during their interrogation or subsequently
Lordship.
justifying their arrest, which is in violation of para 30 of Satinder Antil. That was his sufficient, if I have understood correctly.
But regarding that, I have to look into the checklist, Lordship. I need to follow.
Checklist is yet, my lord, with all respect, my lord.
39.
39, my lord.
In which
Same materials, my lord. 39 of my application.
say 48.
48. My lord, can I just say one more line? Of course, my lord. Let it be over, my lord. Three months.
One line you can say, I think. till he
My lord,
finds
here
out.
was what has happened, my lord. Whatever he has said is correct, my lord. My lord, let us visualize the situation, my lord. Mobile phone, giving mobile phone to the inmates, my lord. With all respect, my lord. Under what section of law it will fall, and under what law criminality cannot be attributed. In jail manual it is there, but my lord, penalty is not provided, my lord. Have I made my position clear, my lord?
3 months, 3 months.
And my lord, by this use of mobile phone, after 37 days, that terrorists were contacted, unlawful activities, those are missing, my lord. NDPS, those are missing, my lord. Till date, my lord, after 37 days. And kindly see, they cannot eat the cake and have it too, my lord. So far as this accused is concerned, he may have taken money, may not have taken money. That's a different matter, my lord. What I am saying, their own forwarding report by which they were, my accused was forwarded, my lord. May I just read it again, my lord? because primarily the accused persons have been arrested much later. As regards the arrest of the prime accused persons, meaning thereby the inmates, my lord, 24, they were arrested. After 4 or 5 months, this accused has been arrested, my lord.
4 months.
So 35(3) and 35(6) have not complied with, my lord. Have I made my position clear? They have been arrested on the existing materials of 35(3). That is, my lord, the law. And thereafter, the forwarding report by which my accused was forwarded, what it says, my lord. Apparently, my lord, the offense is providing mobile phones in lieu of money, my lord. One liner, my lord, with all respect, my lord, that occurs at
Page 23.
page 23, my lord.
Point number
6. I'm reading it, my lord. That is their forwarding report, my lord. With all respect, my lord. After not complying with 35(6), my lord. Accused inmates, namely Iqbal Hussain, Samaruddin, Azharuddin, Abdul Hussain, Sajid Ahmed, Sujan Mia, Habib Ahmed, have consistently named these were the arrested accused persons who use mobiles, my lord. Their 161 statement or whatever be it under BNSS, 180 or whatever be it. Name jail warden Subhasis Ghosh. They name, my lord. Assistant jailor, Rudro Deuri, and jail Jamadar Murshid Ali as facilitators for smuggling and providing mobile phones inside the jail in exchange of money. Where am I, my lord? And what the first informant report really reads, my lord, they cannot eat the cake and have it too. One view here, one view there. In black and white, it is there, my lord, investigating officer. And FIR, my lord, with all respect, my lord, page 18, my lord. Page 18, my lord. Some members of District Jail Authority and security personnel, since the UTPs convicted individuals, both category, my lord, were carrying on their criminal activity within the jail premises while the campus is under round-the-clock security. Meaning they were provided with mobile phones. And regarding providing mobile phones, my lord, the name of the persons whose statements were recorded, my lord, initially arrested, my lord, who use mobile phones, they do not disclose my name, my lord. And 35(6), my lord, despite everything, my lord, we leave aside merit, my lord. On 35(6) itself, my lord, this cannot be carried out. It should not have been carried out.
Yes.
Demand and acceptance, my lord, too far away, my lord. Demand cannot be there because money was paid to there, because 7 they have added, my lord. When 7 is added, materials of 7 are to be there, my lord. Demand and acceptance both are to be there, my lord. Where is the demand, my lord? It is nowhere there, not a whisper. And acceptance through, my lord, with all respect, my lord, the Jamadar concern, my lord.
jail warden.
Jail warden concern, my lord.
7 is the only non.
7 is the only non-bailable section, others are all bailable, my lord. 7 it falls flat, my lord.
Yes.
Only thing I can state here, Lordship, if they want to arrest him, Lordship, they have to give reasons. And here I have found the reasons. Though he has stated it as earlier, Lordship, there are reasons. But one thing also need to be taken into account, Lordship. He is in a higher position, Lordship. He can influence the inmates, Lordship. It also be taken into account, Lordship. Everything
It's a
is not.
separate issue, but
Already transferred.
There is one.
Already transferred, my lord. That occurs at page, we have annexed it, my lord. This argument, my lord, I am not, 35(6) is followed or not. Checklist is given. It is prior 3 months prior hand, my lord. Exactly those materials that occurs at page 39, my lord.
He was transferred, Lordship, on transfer.
This should page 37.
10 February.
10 February.
And he was arrested on 8. He was arrested on 8.
8 June.
8 June.
8 June.
Come on.
Okay, Lordship. Otherwise, Lordship, I have only wanted to point out that thing, Lordship. He is in a position
No, not in a position now, my lord. I was transferred prior to my arrest, around 4 months prior to my arrest, my lord.
And the one thing is there, one point number 4, credible information and evidence collected during the investigation disclosed that the accused person, while serving as public servant in the jail establishment, point 4, Lordship, demanded and or accepted illegal gratification from the prisoners or their associates.
To 10th of March,
Then this point, my
Point
lord,
number 4, Lordship.
the authority was aware of on 10th of March, and arrest was carried out
9th of June.
on 9th of June, my lord. So 35(6) total violation, my lord. And the forwarding report by which he was forwarded, his name is missing regarding acceptance of money through, my lord, intermediary.
His departmental inquiry is against him, Lordship. CCTV footage is not there.
Department in 35(6) or nalge.
No, I'm talking about as a case as a whole, not only point of the 36.
My lord,
35.
nowadays the difficulty is, my lord, let us go point by point, my lord. I think, my lord, I may be wrong also, my lord. What the Supreme Court says, thereafter, my lord, another interpretation, this is dangerous, my lord. The materials under section 35(3), my lord, upon which notice was issued, thereafter 35(6) is to be followed, my lord. It falls flat on that count, my lord. Nothing more is needed. How much involvement is there? Let it be a case of 302 IPC or 103 BNS, my lord. That is besides the point on merit, my lord.
Anyway, Lordship, I leave it to Lordship. I want to submit the CD, Lordship.
Oh, sorry, my lord. In 103, my lord, notices are not necessary. Wrong parallel I stated, my lord.
What one?
In 103, 302, notices are not only 7 years, my lord. That's a wrong thing I have said, my lord.
Here your submission is that since they have issued notice, at that point, there was no necessity of arrest.
Exactly.
Under 36.
Exactly.
According to the IO.
Exactly, my lord.
So, subsequent to notice, upon their appearance, interrogation, everything, if something more comes out, which
Exactly.
necessitates
That
their
is,
arrest,
yes, that
then
is
they
the
can be
tenor.
arrested. But in the present
Police
case,
custody was not even sought for.
all right, we'll see, pass over the CD.
My lord.
Worships may allow should pass over. Worship may allow a short pass over.
Time being over for the
Yes, your
day.
worship. No, for the time being. Item 18.
Item number 18, CD also not received. I has paid for some time to put it.
Lordship, it is 60 days offense already. It is as of today, it is 65 days.
All right, let him come then. CD not received.
19 and 20, my lord, in the morning, my lord, earlier the matter during vacation, my lord, matter was listed before, my lord, court number 3. Well, CD not yet
Lordship,
returned.
in my case, Lordship 19, item number 19, Lordship, I was arrested, the search was made. Gist of the FIR is that on 8, on a basis of secret information, one Rekibul Islam was personally searched. 6 grams of heroin was recovered from his personal possession. On his statement, one Mofidul was arrested and 40,000 was recovered from him. They both were arrested on that day. Subsequently, on 28/6, Lordship, my accused Rasimali was arrested, Lordship. A forwarding report is at page 17, Lord.
Your lordship may fix it tomorrow, day after tomorrow. I will collect the CD from court number 3, man.
All right.
I will get the CD, man.
It was there, most probably. City আসলে তখন তো
Court number 3 হয়েছিল।
I was arrested only on the basis of a statement of the co-accused, Lordship. The first line at page 18, Lordship.
Now, is that point considered that you are
No,
arrested only on?
I have raised the issue of Tufan Singh, then learned.
No. The fact that you were arrested only on the basis of statement of co-accused,
Yes, Lordship.
is that considered by the prosecution?
Yes, Lordship. That is on the page 18, Lordship. Page 18 of accused forwarding report, Lordship. Nothing in the, I am not the FIR named accused, Lordship, here. May I read, Lordship? During investigation of Morigaon PS case number 87, that was registered on 8, the arrested accused persons, namely Rakibur Rahman, disclosed in their voluntary statement that they have been regularly purchasing narcotic drugs from Resim Ali. I am Resim Ali, Lordship. Though case was registered under 27A, nothing single point has been mentioned here of any financing or harboring of the accused.
Point number 3 is there.
Yes, Lordship. Mobile phone seized, registration. This is of trafficking, Lordship. I have got 3 other cases. I have disclosed it. That is of 23, Lordship. One, I am a drug addict. I have made a specific statement in my petition, Lordship.
No,
In
it
23
says during investigation, analysis of the mobile phone seized from the arrested accused persons revealed several communications, contact details, digital information, indicating
Dealing and
continuous
trafficking,
dealing
dealing and trafficking, Lordship. Those may be.
with accused Rashim Ali.
That's it, Lordship. For that part, there must be something recovery for made to be made.
No, not necessary only recovery. If there is other material other than statement of co-accused,
Let them
then
show
that
them
point
show
doesn't survive.
Let them show that.
All right, see after tomorrow.
Day before next.
Because if it is only on basis of statement, then
Purely basis on statement, Lordship.
other than Tufan Singh, now that is section 67 Tufan Singh, but P. Krishna Mohan Reddy, it has been very clearly said.
On Thursday, Lordship. Obliged. Maybe kept as part heard, Lordship.
Pardon.
Or it may go here and there again, that's why, Lordship.
We'll just say, heard Mr.
Sure.
Learned Counsel for the petition and additional is submitted that the present petitioner has been arrested against only on the basis of statement of the co-accused. Learned additional PP takes some time to obtain instructions to peruse the to obtain the CD.
You obtain this.
To so as to verify the said statement or as to whether there are any other material against the petitioner. Further submitted that in view of the settled law on this point, the petitioner cannot be denied bail. Yes, his arrest has been made only on the basis of the statement of the co-accused and nothing else. Full stop. For the purpose of ascertaining the aforesaid factual aspect, the point of law involved is the matter again on
16, sir.
Item number 20 as well.
Take
Item
the
number 20.
same FIR, Lordship.
19 and 20.
Made to Jolov. The FIR is at page number, my lord. 32. Sorry, my lord, it is page number 12. 12. So the incident is of 2017. Basically, my lord, it was a love affair, my lord, between the petitioner and the informant's daughter. And my lord, both of them ran away, my lord, and because of some religious issues, my lord, the marriage did not take place socially. Thereafter, my lord, the father of the girl, my lord, he lost an affair. And during investigation stage only, my lord, petitioner approached this Honorable High Court. And my lord, Lordship will kindly have a look at the order, my lord. And the Honorable High Court granted my lord pre-arrest bail to the petitioner, my lord. Lords will kindly have a look at the order. Absolute bail, my lord.
Kumar Yak reject. 7. Get to co-accused.
Who was granted bail?
My lord Monirul.
Now?
Thereafter, my lord, some other set of counsels, my lord, later on, my lord, again file a second AB, my lord, for both the petitioners, my lord. Lords will kindly have a look at page number 18. Again, they file an AB, my lord. There, my lord, interim was granted, but subsequently, my lord, bail for the present petitioner was rejected and bail for my lord Jahangir was allowed. At page number, my lord, 21. But earlier, my lord, he was already granted EB, my lord. Now, thereafter, my lord, police submitted charge sheet in the year 2021, and my lord will kindly have a look at page number 35. 35, my lord. He voluntarily surrendered before the lower court, my lord, on 12/6/2026. Now, out of 3 accused,
Who
my lord,
surrendered? Page number?
petitioner, page number 35. Now, out of 3 accused, my lord, one is on bail, one, my lord, the mutual friend, my lord, Nazmina, my lord, she is,
Monirul surrendered.
yes,
And what
And-
happened then?
and he was taken into custody, my lord. And their mutual friend, my lord, Nazmina, my lord, she got married and my lord, she is residing in a different address. So, my lord, NBW has been
Where is
issued against her.
no, after this order of 2017,
Yes. Some other set of counsels again filed an AB, my lord,
Hmm.
for the same case.
and there one was granted, one was rejected.
Rejected, my lord. Thereafter, my lord, he voluntarily surrendered, my lord, and he was taken into custody. This order was not considered, my lord.
So who is before us now?
My lord, Monirul Islam, my lord.
Jahangir is out anyway.
Jahangir is on bail, and another accused, my lord, Narzima, my lord, she is Narzima Khatun, my lord, NBW has been issued against her, my lord. So, my lord, my only submission is that, my lord, he is ready and willing to face trial. 2017 issue, my lord. And, my lord, till this other co-accused, my lord, appears, the trial is not going to start anyway, my lord. So, my lord, my only submission is that at this stage, my lord, let him be granted bail, my lord.
This appears to be rather unfortunate after High Court has granted bail against somebody.
Yes.
Comes and it gets rejected.
Then thereafter somebody has filed and bail rejected.
They had counsel for the petition and additional petition under so and so. Yep. It appears that the present petitioner Monirul Islam, along with another co-accused Jahangir Ali, was granted pre-arrest bail by this court by order dated 05/12/2017 in AB 24443 of 2017. Subsequently, however, another set of counsel had filed another pre-arrest bail application on behalf of the same accused persons, and the result thereof was that by order dated 11/7/2018 in the said application, that is AB 1373 of 2018, the prayer for bail of the present petitioner Nurul Islam was rejected, while that of the co-accused Jahangir Ali was allowed. Para, pursuant to the above, the present petitioner has surrendered before the learned court below, and he was sent to judicial custody. There are, needless to say, it is an unfortunate sequence of events where the petitioner, even after being granted the privilege of pre-arrest bail by the High Court way back the year 2017, had to undergo detention. For no fault of his. Having regard to the above, the prayer for bail is allowed. Petition so and so shall be released on bail of rupees 10,000 with a surety of like amount. Section of the
CGM.
CGM.
Highly obvious.
My lord, in this case, my lord, CD was called for.
Item number 50 and 51 will search sheet submitted in this case.
Then, my lord, the record may be called for because, my lord, here, my lord, ground of arrest, legal procedure of arrest is also, my lord, taken.
Already submitted that charge sheet has already been submitted, white CS number so and so dated so and so. Hence call for the scanned copy of the TCR list again on
CS number 10/26 dated 30/6/26.
Obligement.
Please, lordship. This is regular bail application, lordship. The petitioner is in custody, lordship, 70 days today, as on today, lordship. And FIR will find lordship page number 13, lordship. In this case, lordship, the FIR and the 164 statement and 161, lordship, that is 183 statement is totally different, lordship. There is no corroboration, lordship. And however, lordship, the charge sheet already been laid, lordship, and CC already been framed, lordship. So, my lord, kindly come to page number 13, lordship, the FIR, lordship. A translated copy, lordship. And the victim is 17 years old, lordship. And but the as per the FIR, lordship, on the date on 12/3/2026, lordship, and he was victim went to the house of his friend nearby Azara, lordship, and subsequently on 13, lordship, and she returned to her own home, lordship. But on 13, lordship, the the victim father informant not found her in her house, lordship, and subsequently lost this FIR, lordship. But kindly come to, lordship, the 164 statement, lordship, I have annexed, lordship, page number 29. Page number 29, lordship. The translated copy. There is nothing there.
Let's say in 161.
So it is 161. I have not found the CD, lordship. Otherwise, lordship, in 183, she has stated one other thing. I have read the charge sheet, lordship. It has stated that in CWC statement, she has stated the things that he has forcefully taken her to an vehicle, lordship, and physical relation has been made forcefully. And on that basis, lordship, charge sheet has been submitted. It is there in the charge sheet, lordship.
There is the veracity of statement, lordship. There is nothing corroboration, lordship, and the victim is second 2 times, lordship. Her statement has been recorded by the police, lordship.
In 161 statement is also against.
What is against? Then
George
one
Zapata-
164,
George Zapata states.
164 lordship.
Otherwise, CWC statement is there in the charge sheet, Lordship. But I have not found that statement, Lordship. Jaldi sai sakhiye.
Where read the lordship of first 164, 183 statement lordship.
That we have read 2 times already.
Lordship. And I have also the 160,
Moreover, in this case, POXO is there, Lordship. So, his name are there, respondent number 2.
Is the date of occurrence,
lordship, as per the FIR lordship, that is 13, the contents of the FIR reveals lordship 13. But lordship, the case is registered on 25/3 lordship, 13/3. FIR page will lordship 13 lordship. But victim says I returned from my friend's house on 13/3.
next day?
Next.
Any document of indicating recovery?
So,
164 is 183 is a story she made up later on. But apparently she went voluntarily and spent some time and came back when police case was there.
I have also seen she has refused medical examination. Also, she has refused.
Refused medical examination.
Medical examination refused, Lordship. However, in 33, she has stated this thing, and in the
What is the proof of
CWC
age?
64 Lordship. It was again later on,
What is the proof of age? Birth certificate.
Lordship. Police has stated that she is 17 years.
But actually 17.
Seizure list is there, birth certificate is there.
Lordship.
Third learned counsel for the petitioner and learned PP. This is an application under so and so. Allegation as per the FIR is that the petitioner along with some others kidnapped the daughter of the informant aged about 17 years, committed rape upon her at an unknown place. Frequently, the victim returned home about 4 days later. The learned counsel for the petitioner with reference to the statement of the victim under section 183 PNSS before the learned magistrate has submitted that the victim has somewhere implicated the petitioner. Full stop. A perusal of the said statement supports the contention of the petitioner. Full stop. The case investigation of the case is over, culminating in a charge sheet which appears to be based on the statement of the victim before the police and the Child Welfare Committee, wherein she has made allegations of rape. Keeping in view the contradictory nature of the statements of victim in regard to the fact that the investigation petitioner has spent how many days?
70 days, Lordship. 5/5/2026.
70 days in custody. The prayer for bail stand allowed. So and so self bail of rupees 50,000. Two sureties of like amount. Further provided that the petitioner shall not try to protect the victim or her family member or try to intimidate or influence them in any manner and cooperate with the trial of the case. Petition stand.
Deeply obliged, Lordship. Special Judge POCSO, Kamrup Metro. Deeply obliged, Lordship. Obliged.
Dr. May kindly pass out the matter for time being, Lordship. At 2, Lordship.
All right.
At 2, Lordship. Yes, Lordship.
May I please, your Lordship? Lordship, Lordship, most probably CD is not there, but
It is
Lordship,
not available.
here is a situation.
CD not available.
Here is a situation, Lordship, what happened? The father of the petitioner, earlier he was in ICU. Now, Lordship, he was transferred to the ventilator. So, Lordship, I'm pressing for an interim bail, Lordship, because, Lordship, his father is in the last stage. Suppose, Lordship, in future, he may be guilty of this offense. Years after years, he may remain in jail, but for the sake of humanity, for the last chance of visiting his father, at least, Lordship, for 7 days, he may be granted bail. Thereafter, I will surrender. At least for 7 days. For seeing my father for the last time. He is in ventilator. I have filed the report by this additional affidavit in this morning. And Lordship, moreover, if we go through the FIR, directly my name is not there, and this person who is directly named in the FIR granted bail by the sessions, additional sessions. And case is also the extortion, the victim was kidnapped. Later on, some money snatched and a gold chain snatched. And he has been released in front of the police station. This is the case. No injury at all. And Lordship, my name is totally directly not there in the FIR. Although my name is there, but in the statement of the FIR, some other people's name are there. A main culprit is some Dibbojyoti Barua. All allegations are against him. Totally, Lordship, I am not pressing for final bail, only for interim bail, because of my father's seriousness, was the last stage of his life. On any condition, my lord.
You are named in the FIR.
Lordship, yes, I am saying that my name is there in the FIR, but if we go through the statements, may I read, Lordship? Here,
In that case, Lordship may go into the forwarding report, point number 3, Lord.
wording number 3.
The examined witnesses reveal the involvement of all four
Co-accused
accused
statement,
persons.
yes, Lordship.
His name is also there, Lord.
Co-accused statement is
Not
there.
co-accused, it is examined witnesses. It is not co-accused.
All right. Lordship, therefore,
Number
I
3.
am submitting here, Lordship. I am not pressing for any final bail. Lordship may direct me to surrender also after 1 week. Because of this situation, for the last chance, I want to visit my father. In future, Lordship, I cannot visit because he is in ventilator.
So he will not know even if you visit him.
Lordship, my duty is there because being a elder son, some payments I have to make. And there is none to look after him. My mother is also not so much capable of these things in hospital, taking care of his father, bills, medicines, etc.
What about the other co-accused? They are in jail, arrested.
Yes, Lordship. Here, Lordship, page number 20, Annexer B. Rintu Datta, arrested. Manas Potim Gohai, arrested. Me at 3, arrested. And last one, Binod Kumar Sunwal, arrested. These persons are arrested. And one Madhusmita, and she has been granted interim bail. I have given this order, Lordship. Her name is also there in the FIR. And in the FIR, Lordship, it is directly stated here that Srijut Dibbojyoti Baruar Netritwat. Others, thereafter, names of the other accused are follows. The main allegations against this person, Dibbojyoti Barua, Teor Netritwat, Rintu Datta, Jodu Bora, Pradip Bora, Midusmita Fukan. These names are there in the FIR. My name is not there. My name comes later on.
Well, 30 days already.
Already 30 days, Lordship.
1182 is there.
Hmm?
Previous injury is there. Added, Lordship. 1182.
Yes, yes, yeah,
Yeah, we can give him an interim of 7 days.
Yes, Lordship.
Had learned counsel for the petition and learned additional PP. ED as called for has been received. Learned has not been received. Learned counsel for the petitioner submits that petitioner may be released on interim bail in order to enable him to see his father, who is admitted the ICU of what Srishti Hospital,
Yes, Lordship.
Dibrugarh,
Not in ICU, in ventilator, Lordship.
ventilator of the hospital, Dibrugarh. Petitioner has already spent 30 days custody. Having regard to the prayer of the learned counsel for the petitioner, it provided that the petitioner shall be released on interim bail of rupees 50,000 with 2 sureties of like amount for a period of 7 days in order to enable him to visit his father in the hospital. It is further provided that during this period, the petitioner shall not try to influence or intimidate the witnesses or tamper with the evidence in any manner. Further directed that the petitioner shall once again surrender before the learned court below on expiry of 7 days from the date of his actual release from custody. List the matter again on.
Deeply obliged, my lord.
Pending item 49.
May I please, your lordship? Earlier, your lordship was pleased to reject this, your lordship. And 20 days at the relevant point of time, when your lordship was reject that, FIR, your lordship will find that page 13. Now 42 days, your lordship. In view of that, probably further custodial interrogation is not required, your lordship. That's allegation is, your lordship, collecting money for parking, your lordship, by using force. Page 13 is the affair. And your lordship's order is at page 32. To my instruction, your lordship, one of the accused has already been granted bail by the court bill session judge, your lordship. Since that is my instruction, only this person is left. Page 13 is there.
Why could you not get that order?
Lordship,
Why could you not get that order? That
lordship,
release order?
since your lordship has rejected it, your lordship will fill it with the.
No. That order whereby Sessions Court has released.
That is why I am submitting, that is instruction. They said that they are not providing it, the other person. Probably further custodial detention is not required, your lordship. And in fact, your lordship, I have also annexed my lease agreement based on which, your lordship, I am operating in the Meghalaya side of the border, your lordship. This. Be that as may, your lordship. Only on the
Yes, I
ground.
think we can, if co-accused has been released according to his submission. So
Otherwise, I pay for calling CD.
Hmm?
Otherwise, I pay for calling CD because 308 is also dear lordship.
That-
Motion case.
This has already been rejected, Your Lordship. That is why CD or Lordship has perused, recorded now only on the length of detention, Your Lordship.
And heard learned counsel for the petitioner, senior counsel for the petitioner. Page 33 যাব first, second, third,
ABL is the
fourth, up to fourth. An earlier bail application being bail application number 1584 of 2026 was rejected by this court by order dated 24/06/2026. So since then, not since then, by now, however, the petitioner has spent 42 days custody and is submitted by learned senior counsel that as per his instruction, another co-accused has been granted bail by the learned session judge, Kamrup Metro, although copy of the said order is not available. Where having regard to the nature of the allegation and period of detention undergone, further detention of the petitioner is not necessary. Bail is allowed. 50,000 to security satisfaction of concerned Dhaka magistrate.
Deeply obliged.
May I please, Your Lordship? Not available, Lordship. Petitioners are on interim.
Interim is there, Lordship.
Not available.
Not available.
He did not receive his interim to confirm till next.
Highly obliged. Highly obliged. May I please, Your Lordship?
Not available, Lordship.
Lordship, interim
Same
of
order.
their interim may continue.
24/7, no?
May I please, Lordship? The 23 and 24 are Lordship arising out of same affair. What the cases, Lordship, they are on interim bail. Now, such
Steve.
Yes, my lord, TCR was my lord called for my lord, that was received, my lord. Yeah, my lord, that is my lord, interim was granted, my lord, earlier. Thereafter, my lord, they appeared. In the meantime, my lord, charges submitted, my lord. And cognizance taken in the matter, my lord, summons issued, my lord, they appeared as because the interim was there, my lord. The my lord, learned, my lord, trial court, my lord, on interim, my lord, interim was, my lord, granted. And my lord, now they are waiting for the final order, my lord. Only, my lord, the part is that, my lord, regarding the grievous injury, medical legal report is there, head injury is there, my lord. That is my submission. Otherwise, my lord, before committal court, my lord, session tribal matter.
Doesn't appear to be any proper description of the injury, just head injury.
My lord, because my lord, in the next side, my lord, some my lord, they stated my lord assault, my lord, but grievous, my lord, and also my lord, one my lord. Other than that, my lord, no, my lord, there is the blunt force or sharp weapon. Those parts are not there. Yes, my lord, that part is. The medical legal report, my lord, in the next.
Regard learned counsel for the petitioner and learned. There is an application under so and so. FIR.
FIR, yes. Type copy loss at page 12. The translated copy.
Allegation as reflected in the FIR is that on 25/1/26, 24/1/26 at about during the night time, the victim was assaulted by 13 persons, one of whom was allegedly the present petitioner. As a result of which the victim sustained grievous injuries to his head. There, the petitioner was granted interim protection by this court, pursuant to which he appeared before the IO. His statement was also recorded. Subsequently, investigation has been completed and charge sheet has also been submitted. And the petitioner had appeared before the learned court below and was allowed to go on bail in view of the order of interim pre-arrest bail granted by this court. The scanned copy of the TCR has been received and perused. Although the medical legal report indicates previous head injury, having regard to the fact that the investigation has been completed by now, there may not be any necessity of remanding the petitioner to custody at this stage. Accordingly, the prayer for pre-arrest bail is allowed. The order of interim pre-arrest bail dated
Lordship, your
9/2/2026, my lord.
6 is hereby made absolute.
No, Lordship, interim order is Lordship 27/2/26.
Huh?
Interim order is 27/2/26.
7 to 26.
Lodge. Oblige Lodge. 24 is same Lodge.
This will
23 and 24 same.
all right.
Both are the my lord.
Huh?
24 is same Lodge, arising out of same affair. Lodge.
Yes, yes.
Wait, please, Your Lordship. So in this case, the updated case day was called for. Prisoner is on interim bail, Lordship.
CD not received, my lord, in this matter.
Updated CD not received.
Yes, my lord.
Interim or list again on so and so. Interim to continue. The next letter of list.
20. July.
Oblige.
36.
To the lordships. And my lord, NCP is there. Here, my lord, anticipatory bail on the basis of a 67 notice provided to us. And they have filed objection, NCB.
But NCB council was there, my lord, earlier. DSGI and her also there. Maybe, my lord, they may be, my lord, communicated. They will come, my lord.
Take up at 2 then. It's already 1.
At 2 p.m.
This is your lordship. And 6 lordship, indulgence lordship. In with regard to item number 52 lordship, I was legs in court number 6 lordship, so I couldn't appear at that time. But today I had filed one objection in that case.
52.
Yes, lordship.
What happened? 52?
It's a POCSO case, lordship, and I had filed objection today.
If we have a past order,
Yes, lordship.
then that's done. We are not
Lordship,
going
for
back.
re-recording of statement, petition is pending before the trial court. Re-recording of statement under 183.
You have missed the bus.
Lordship, I was in legs, lordship, this is the reason.
We are not bothered. Should have left someone. If you can't handle the cases, then don't take it.
May it be the my lord, I approve this court by of a PRS bail on receipt of a notice under section 67. They have filed objection. They have said my name is not in the affair only because there are some communication with the telephone with the accused. That is what their objection. That is why they need a custodial interrogation. And I want to, as my prayer will be regular, my lord, I will approach every day before the IO that protection, my lord. And the objection, my lord, a copy? Am I giving a copy to him? Yes, said in the paragraph that the communications are there with telephone. That is there. And telephone CDR. Paragraph.
No, it's a matter of more than 6 kilos of heroin. And petitioner, as it appears, happens to be the buyer. Since other persons who were carrying it, they had diversed that it was to be given to the petitioner. Now, there are telephonic communications between the petitioner and those who have been. The ring may be bigger, lordship. Therefore, we would be seeking a custody. It's not a small amount, more than 6 kilos of heroin.
Where is the objection? It's there.
It is there, lordship.
Your lordship has got the objection?
Yes.
Relevant para, my lord, what I find is, my lord, at para 9 and my lord, para 19. Nothing was recovered from me and neither, my lord, my name is there in the affair. Para 7 also is there. Right.
So if you have been found in contact with the,
Not that telephonic.
then how can you say that your custodial interrogation is not necessary?
My lord, I am not saying that interrogation is not necessary. I will approach the authority every day and will cooperate. But necessity of giving me some custodial interrogation is how much? That much is the point. If I don't go against the witnesses, neither evidence, because nothing was found from me, I will cooperate with them. But whether custodial by giving some torture to me to get out something, is it necessary?
Even without torture, Supreme Court has said that custodial interrogation is more effective in eliciting the truth.
Because some directions that I understand, well, some directions that I will appear every alternative day. That much also, that strict consideration may be given. Every alternative day I will appear.
I have got some reservation. That is a concession submission made by the council. Once the bail is granted, lordship, we have experienced in some other cases, I've come for cancellation of it. Once bail is granted, they are nowhere to be found.
My lord, all the fingers are not same. My friend and me are not the same.
Today there is a matter. I have come for cancellation of bail in another court.
Well, your lordship will give that consideration. If I don't appear on one day, the bail will be cancelled. The privilege of anticipatory bail will be cancelled. If I don't appear one day, that observation can also be given, madam. Automatically, it may get cancelled. That protection.
You've got the, otherwise the case record, anything is there with you?
No.
What do you people maintain in the form of a case diary?
It is in the form of an official record, lordship. Your lordship pleases, I can.
So your objection takes the place of the CDA. All right, saves us trouble and time. Anyway, we'll fix it for delivery of order on Friday.
Friday. Obliging.
Lordship, I will not be here. My colleague will be here.
Okay. All right.
My lord. So, my lord, there was a road traffic accident, my lord. This is a case of 103, my lord. Unfortunately, the victim, who was allegedly injured on 15th of May, he expired on 24th of May. He undergone treatment in Metro Hospital first, subsequently released, again admitted to Health City Hospital, and there he expired on 24th of May, my lord. And my lord, he was a retired DSP, my lord. Deputy Superintendent of Police, retired. He was 61 years of age. And my lord, on that evening, my lord, what happened, my lord? His vehicle, my lord, collided with the vehicle of the present petitioner, and then he and his two sons and the petitioner, they had a commotion, my lord. Very unfortunate, my lord. And then, my lord, on that commotion, he fell down, my lord. He sustained injuries, and then, my lord, it resulted into this, my lord. This is just an unfortunate, my lord, event that has occurred, my lord. No intention, my lord. No preparation, no motive, nothing, my lord. Already 50 days, my lord, behind the bar, my lord, and investigation also, my lord, by now must have completed. So, my lord, at this stage, my lord, FIR is at page 11, my lord, type copy. May I read, my lord? Page 11.
In that,
And my lord, they have lost the FIR on 9th, incident is of 15th of May, my lord. They lost the FIR on 19th of May. I have lost the FIR immediately on 19th, my lord. Kindly come to page number 20, my lord. That is my FIR on the day of incident, my lord. Duly received by the officer in charge of the same police station, that is Vasistha PS, where they have lost the FIR. Same day, my lord. Immediately, I have lost the FIR. No weapon use, my lord. No preparation, no motive, my lord. Rest, I will face trial, my lord, now. Whether it is a case of 1031 or it is at best a case of 105.
yes, PP.
My lord, here I have received the case there, my lord. Here, regarding my lord, PM report, my lord, final opinion not received, yet to be received, my lord. Viscera, it was sent for my lord FSL. It was
This is not a case of poisoning, but is
report,
to do it.
also received, my lord.
What is
But
there?
here, my lord, from the inquest report, my lord, here an injury mark in the backside of the head scene. Injury mark. Thereafter, my lord, PM report also seen, my lord. Here, post-mortem injury present over left upper limb, back of neck, and occupable area of scalp at places. Injuries. And from the witnesses, my lord, Lordship may kindly peruse, my lord. Doctor statements are also there.
He fell down, my lord.
And even the accused also admitted that he has assaulted the deceased man.
So FSL report is also there.
My FSL report is there.
So there is no poisoning. Some
Fine.
alcohol was found.
Fine.
So it was because of the assault only. That is because of the assault.
My lord, my lord. That is my,
Ribs are broken,
My
injury on the head,
my lord.
multiple injuries are
My
there.
lord, my lord. Doctor statements are also there, my lord. Head in.
And after the body was lying there, you were threatening the sons of they pay the money, otherwise.
That is his.
My lord, they were- some my lord interested witnesses also there, my lord. That is his locality, near his house. Well,
Some
change the time.
witnesses.
The retired my lord DSP, my lord. And if they hit in the vehicle, my lord, he has assaulted brutally, my lord. Hereafter he fell down and thereafter my lord threatening part. Such type of behavior, my lord, at present.
All this, my lord, he will face trial now, my lord.
Not at this
Investigation,
stage, my lord.
investigation, my lord, already almost completed, my lord. There is one incident, my lord, of an evening, my lord, police must have completed the investigation, my lord. Now keeping me, my lord, will be by way of punishment only, my lord.
We can't just let you commit a crime of this nature and walk out on the ground that investigation is completed.
Fine.
Then, my lord, let it be kept pending, my lord. Let them investigate, my lord, whatever is there, my lord. Now 50 days, my lord. Let them complete the investigation, my lord. They may file an up-to-date case diary.
Is up-to-date case diary. We have sufficient material here against you. Heard learned counsel for the petition and additional PP. This is an application in the pencil. The petitioner was arrested on 25/5/26. Para 2 of order dated 2/7. It is submitted by learned counsel for the petitioner that an altercation took place between the petitioner and the deceased as a result of a road accident, and the the deceased thereafter fell down and sustained injuries. In this regard, also in this regard, the petitioner had also lodged an FIR on the next day,
Same day,
on the same day, which was received, although by the police, but no case was registered. Full stop. The CDS called for has been received. The FSL report has ruled out for any poisoning. As full stop, as per the PM report, is that the deceased sustained multiple injuries on his body, including his head, and also fracture of the ribs. And the statement of the doctor also indicates that the victim. Deceased died as a result of the head injury. Having regard to the gravity of the offense, the prayer for bail stands rejected at this stage.
Obligation.
May it please your lordship. In this case, CD was called for. The petitioner is behind the bar since 65 days, my lord. 60 days offense, my lord. Already is 65
Instruction
days.
regarding CS.
Well, here we have not received the case diary today, my lord. Here I has paid for said that it was lying in the office of the chief judicial CGM. CD is lying in the CGM, my lord. 118 subsequent.
Section involved is, my lord, 118(2), my lord.
Perhaps previous hurt, my lord.
Grievous hurt, my lord, then not less than 1 year,
It's the
but
90 days offense, my lord.
may extend to 10 years, my lord.
This offense means refer to subsection 1 shall be punished with imprisonment for life or imprisonment either for a term which shall not be less than 1 year, but it may extend to
May extend to 10 years, my lord.
earlier 326.
No, it will be a 60-day offense.
Yes, my lord.
326 is a 60-day offense. It is up to life. Minimum is
life.
not 10.
My lord.
Minimum is not 10, my lord. Minimum is 1 year.
You have spent 65 days.
118 subsection 2. 118 subsection 2.
Yes, minimum is not 10 years.
Yes, my lord.
In order to make it a 90-day offense,
My lord.
it should be more than 10 years. Minimum is should be 10 years.
My lord. Minimum is to be 10. Punished with imprisonment. First line, my lord, whoever except in the case provided by for subsection 2 of section 120 voluntarily causes grievous hurt by any means referring subsection 1, my lord, shall be punished with imprisonment for life. Or life, imprisonment for life, or with imprisonment
This
either
may be, that is not the minimum.
my lord, my lord, my lord. But here in the FIR, my lord, it's
167 is now 187.
my lord.
CRP,
Fine.
BNSS.
187. Subsection 3 1. 187.
90 days for the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for term 10 years or more.
This has been interpreted
My lord.
saying that minimum 10 years is required.
Minimum 10 years, minimum 10 years.
I think Rakesh Pal, it has made it clear.
After some time, we start sheet submitted, then I'll take instruction after 5 minutes. After 5 minutes, if start sheet submitted.
All
But your Cattle Preservation Act has been invoked, my lord. FIR, my lord, is page number 17A, my lord, the relevant portion. 17A, my lord. My lord, the date is 17/2/2026. Now, my lord, in this FIR, the allegation is against different people, my lord. There is a vehicle involved, which is Bolero vehicle, AS 15 AAC 7359. This is not related to us, my lord. Now, my lord, I would invite your attention to page number 24, my lord. Because there is no allegation against us. Now, 24 is the seizure list, my lord. This is 16/3/26, 27 days after the FIR. Now, in this FIR, my lord, on 16/3/26, the petitioner, who is the driver of this vehicle, which was seized, my lord, AS 13 AC 6234. This is a Tata Ultra truck, where around 24 number of 22 number of cattle was seized, my lord. So in the FIR, which was lost 27 days earlier, in that FIR, my vehicle was shown as seized. Now, my lord, the petitioner before your lordship is only the driver, and the transportation was being done within the same district, my lord. Now, because everything has been seized now, the vehicle, the cattle, my lord, the custodial interrogation is not required, my lord. I will appear before the police under any condition, my lord.
What is your name? Shahjahan. What?
No, my lord, it is Rashidul, my lord. His name, his vehicle, do not find mention in the FIR, my lord.
What is the connection between this FIR at page 17A and this seizure list at page 24?
Hardly any connection, no connection, my lord. No connection.
Where is the FIR of your case in
So
respect of
that
which
is
you are
what, my lord,
seeking
that is,
bail? Huh?
this is the FIR number. The FIR which was lodged on 17/2, they have shown seized under that FIR. There is no FIR against me, my lord. There is no FIR against me. This is the FIR.
So how do you relate this?
Page number 27, this is the court's order, I think under 1063. This after the product was seized, my lord may see this. 38, Gusaigaon PS case number 3826.
38 or 338?
My lord.
Type copy says 338.
GD number, my lord. That is in the seizure list, but this order, my lord, page number 27 and 27A, this makes it clear, my lord. Gusaigaon PS case number 38. In the seizure list, GD number is there, 338. But in this order, this is the same vehicle number, same MR number 06, which is also mentioned in the seizure list. So effectively, there is no FIR against me.
PP FIR, it is mentioned 8 cows.
Yes, my lord.
It is another vehicle, my lord.
That is another
It
vehicle.
was seized from the another vehicle.
Then how
Subsequently,
can be the same case number?
my lord, subsequently, my lord, another vehicle was apprehended by the police, my lord. It was from the vehicle, my lord, 21 numbers of my lord cattle were recovered, my lord, which was carrying in a my lord very cruel manner, my lord.
No, that was 27 days later. How is it connected to this case? We have shown it seized under the same case.
My lord. The seizure is at on 16/3, my lord. 5/18, my lord. Here, lordship.
That is what 16.3. After nearly a month, another vehicle is seized.
My lord.
So how is it in connection with the same case? Gosaigaon PS 38.
The later part of the CD, my lord, it was reflected that, my lord, from the information from the officer in charge, my lord, it was one vehicle was, my lord, intercepted, my lord. And from that, it was 20 numbers of cows were recovered,
Then there should have been a separate FIR.
my lord. That I will have to take instruction in this regard, my lord. Perhaps for that reason, my lord, it was up-to-date CD was called for, my lord, in the last occasion also, my lord.
Yes, that something must have confused the.
I will be protected, my lord. By then, they cannot go and filing an omnibus FIR and seizing every cattle and
No, my lord.
vehicle, my lord.
From the CD, later part of the CD, my lord, it reveals that he is the person, my lord, driver of the vehicle, my lord.
I am
And
agreeing, my lord.
What happened, my lord, in this case, my lord, it was স্থানীয় শ্ৰমিকৰ দ্বাৰা গাড়ীখনৰ থকা আলু, কবি আৰু গাজৰসমূহ নমাই গৰুবোৰ উদ্ধাৰ কৰা হয়। It was under my lord আলু, কবি and গাজৰ। গৰুবোৰ উদ্ধাৰ কৰাৰ সময়ত দেখা যায় যে গৰুবোৰৰ চাৰিওখন ভৰিত ৰছীৰে বন্ধা অৱস্থাত পোৱা যায়। One S vehicle, my lord, there are 21 numbers of cow, my lord.
We understand all that.
My lord. And even owner of the vehicle, my lord, it was said that it was driving by the present petitioner, my lord. Owner of the vehicle, my lord, in his state, it was driver was the, my lord, present petitioner of the, my lord. Here he has taken পশ্চিমবংগৰ পৰা গাড়ীত কেঁচা মাল আনিব, but behind that, my lord, 21 numbers of cow, my lord.
No, but how can you connect two incidents, two separate incidents, different persons, different vehicles
My lord.
under the same FIR? Get a clarification, we'll take up on Friday.
My lord.
Lord, I will protect it till then, my lord.
Matter of
Not
4
a-
days, what is there to protect?
Grateful.
Had learned counsel for the petitioner and learned additional PP. It transpires that the FIR relating to Gosaigaon PS case number 38 of 26 is dated 17/2/26, whereas the seizure list involving the present petitioner is dated
16/3, my lord.
16/3.
16/3/26.
and there appears to be no plausible explanation as to how the said seizure list is connected to the FIR. of Gosaigaon PS case number 38 of 26, dated 17/2/26. Mr. Bernard, additional PP2. Take instructions in this regard. List the matter again on
17, my lord.
Can it be taken on Monday, my lord, then? In that
Alright.
case? Monday.
Into.
Grateful.
Item 20.
My lord, CD was called in this case.
Not received, my lord.
No, for the fourth occasion, CD has not been received, lordship. We are not in protection, lordship. There are two female petitioners, lordship.
My lord, here 103 is there. my lord.
103 maybe they are.
103 is there, my lord.
10
That is why there should have been more urgency in producing the CD.
My lord.
is there, but we are the family members. Men,
Having regard to
My
the
lord,
fact
sorted
that
will
the
be-
vacations were there, we'll post it on
My
a
lord, sorted may be given, my lord. We'll
Alright.
put this case there.
Friday.
No, my lord. 22nd, my lord. Tuesday, my lord.
CD is not received. It appears that on the last two occasions also, CD has not been received. And further opportunity is granted. Produce the CD, list the matter again on
22nd, my lord.
online, lordship.
My lord, it is a well application. I am
My
on
lord,
a.
here charge sheet submitted, my lord.
What is the offense?
109 is there, my lord. Attempt to murder. 109, subsection 1.
What happened?
1182 is also there.
On 25 of May, on 25th of May, my lord, interim granted. And yes, my lord. Interim granted, and 28, the petitioner appeared before IO. And then IO stated the charge sheet has already been laid, my lord. Charge sheet, it was prepared on 24/5, showing the petitioner as absconder. And it is submitted before CI court on 2/6/26. And it was seen by the CJM on 13/6/26. While difficulties, my lord, I have been shown as absconding accused, my lord, here. Interim my lord, it may be made absolute, and I may be allowed to appear before the his magistrate.
One 103 is there. Huh? 1182 is also there.
My lord, 1182 is there, 1091 is also there. 112 is grievous by surplus.
No, we can give you protection till your appearance, but
My
we
lord.
cannot make it absolute unless we see the,
Can copy.
yeah.
Then what will scan copy may be called for.
Alright. Submitted that CS has been submitted by
I charge sheet number 40/2026 dated 24/5/26.
And it may be tagged, my lord, another item is AB 1064.
for the scan copy of the TCL. List the matter again on so and so along with
AB number 1064 2026. That is fixed on 17th, I think, my lord.
okay. Yes.
Obliged, my lord.
So is, so right, Lord, instruction regarding the service, Lord, first, call for launch.
Yes, any instruction?
Yes, my lord. Instruction, my lord, we have received, my lord. This, my lord, service is completed now. Appointed, my lord, in this matter.
Okay, we'll appoint an amicus then.
My lord.
Counsel for the petitioner, learned additional people. On instructions, written instructions, if submits that notice on respondent number 2 has been served. However, none appears for the respondent number 2 accordingly. And so is appointed as the respondent number 2.
That communication may be kept as a part of the record. My lord.
Of the IO may be kept as part of the record. What about CD?
TCR.
TCR, my lord, that is already, my lord, come.
TCR has already the matter for.
But sir, can it be on 17? Because the trial court date is on 18, Lordship. And the last opportunity was given to the petitioner. We have annexed the
All right.
on Friday next, 17.
You have to serve extra copy on the amicus.
Lordship. On 17, man. Must.
Please, your lordship. Pre-arrest bail application, lordship. On the last occasion, lordship has called for the medical report of the victim, lordship. Your lordship will find the affair is at page 8, lordship. Your lordship. Although they brought the allegation of lordship, the gang rape, lordship, but at the time of arrest offense, lordship, the accused number was not even in India, lordship. He is at that relevant point of time, he was in Kuwait, lordship. And on the last occasion, I had shown some document, lordship, that the accused number 1 was in Kuwait, lordship. He, prior to the date of incident, lordship, from the Kuwait has sent something, lordship, to the India, lordship. If your
Yes,
lordship,
is it there, FSL medical report?
My lord. See, first of all, my lord, 183 statement, my lord. In that statement, my lord, C category stated that both of the present petitioner has committed the offense, my lord. Hereafter, my lord, medical report here, my lord. Medical was done on, my lord, the FIR was, date of occurrence of 3/5/2026. And medically examined on 7/5/2026, my lord. And FSL report, my lord, it was in the kind of thing.
there are some lordship, some land dispute, lordship. The petitioner number 1, the petitioner before your lordship is a caretaker of the accused number 1, lordship. He residing in lordship Hosai. Because of some land dispute, they have been falsely indicated. Because I have the document with me to show that the accused number 1 not even present in India, lordship, at the relevant point of time. Very false allegation.
Where is the FIR?
FIR is at page lordship 8. Is a translated copy. Vernacular your lordship will find is at page 12. The type copy, type FIR, lordship, and page 8 is the translated copy, lordship. Incident arrest to have been occurred on 3/5/2026, but they lost the FIR on 5/5/2026, 2 days after day of occurrence, as stated in the FIR.
Him is a 46 years old lady, Lordship.
Yes, PP, anything else to submit?
My humble submission is that, my lord, from the 183 statement, my that offense was committed, my lord, both of them. Although medical report, my lord, FSL, my lord, it was examined, my lord, after 2-3 days, my lord. As he is the 46 years of age, my lord, nothing remains, my lord, after 2-3 days exams. My humble submission not at this stage, my lord. Such type of offenses, my lord, no anticipated.
What about his alibi? Wait.
My lord. My lord, in the annexure 3, my lord, here name is Ahmed Mohammad Farooq Abdul Mannan, my lord.
Father's name is there along with the,
Annexure 3, my lord, page 16, my lord.
yes.
His name is mentioned as Ahmed Mohammad Farooq Abdul Mannan, my lord.
Other name is added along with it.
What is his name then?
His name Lordship Farooq Ahmed. And his father's name is Abdul Mannan.
Where is that in Annexure 3?
Annexure 3, Lordship, the father's name is also added along with the name of the petition, accused number 1.
In middle
Mohammad
portion.
Farooq Abdul Mannan. Mohammad Farooq Ahmed Mohammad Farooq Abdul Mannan. Next page, Lordship, kindly come to the page, page 19. That is the civil ID issued by the Kuwait authorities, Lordship. His name is Farooq Ahmed Mohammad Farooq, and civil ID number is Z5425897. That is, which is also appears in the page 16, Lordship. He sent money, Lordship, one day day before earliest date of Lordship occurrence, Lordship. 4/5/2026, Lordship, he sent money from Kuwait, Lordship, and the allegation is 5/5/2020.
No, if you were in Kuwait, you should be able to show that by entry in your passport.
My lord, but here
Entry, Lordship, because he has been in out of India, Lordship, 5/4/2026, Lordship.
the documents
5/4/2026.
easily available in the computer center also. Authenticity regarding the bill.
Another, Lordship, another.
No, what is the document to, other than those sales receipts? Forget it. Anybody can obtain a sales
My lord,
receipt.
that's a computer center.
Because
it
in
is available.
page number 16, Lordship,
Hmm.
your Lordship will find there is a civil ID number. The person, none other, the person, Lordship, has sent money through the international exchange, Lordship. Civil ID number so and so, and your Lordship will compare the page 16, Lordship, along with page, Lordship, 19, Lordship. Only compare page 16, Lordship, with page 19, Lordship. Civil ID number also appears in page 19, Lordship. Instead of Kuwait, civil ID card, Lordship, civil ID number. This civil ID number also appears in page 16, Lordship. Yes, because Lordship, I am the caretaker of the Lordship, the accused number 1. I reside in Hojai, Lordship, and I look after the property of the accused number 1. There was a land dispute between the informant and the Lordship, the accused number 1. I have been implicated in this case.
Your name is what? Petitioner's name is Mahir Abbas.
Mahir Abbas, he is the accused number 2, Lordship, in the affair. By Lordship,
You are not residing in Kuwait.
no, I am not.
Documents of
I am showing the owner. I am the associates of the associates of the accused
So-
number.
Can understand in his petition, he is taking
God,
this
no.
claim, but you were never in a Kuwait.
Why I am
except
saying
where-
this? Because they erase the allegation of gang rape, Lordship. If one is resides in Kuwait, Lordship, at the relevant point of time, how gang rape would take place, Lordship? And this is a serious allegation have been brought against the petitioner, Lordship. But FIR was lost after 2 days, Lordship, and that too is a type copy, Lordship. I have the document which goes to show that the petitioner, even the accused number 1, not even there. Lordship, If your lordship granted the bail, I can produce everything before the investigating officer so that the investigation would go in proper way. Lordship. Completely false allegation, lordship. Legal report perhaps also silent.
We are finding it difficult to understand how you have established that.
My
you are in
lord,
Kuwait.
with the help of documents of the other person.
No, but even if the other person, because these are technical things, what is this?
There is a categorical
Whether somebody else
lordship.
can also send money
My lord,
under
but
that,
my lord.
that name.
On the date of incident also, lordship, the petitioner purchased something in Kuwait, lordship. The money receipt also I have annexed.
So where from your passport is it there? If you are in Kuwait, you are an Indian national, there will be a date on which you have
For which
left
period,
for
my lord, is?
Entry, lordship, Ministry of Interior, Central Department of Anti-Exist Procedure, Anti-Exist Movement Report issued by Kuwait authorities. Last entry 5/4/2026. Page 22.
5/4 entry. What is this? Arriving from or departing to?
Passport Department and entry Saudi Arabia.
Where it is arriving from or
My lord, or
what is this?
departing to.
What is the date of alleged date of incident?
5/5/2026.
5/5.
Yes, lordship.
This is 5/4.
5/4, my lord.
It is 5/4.
1 month ago.
I submission is that, lordship, the humble summary, the petitioner accused number 1 has been in lordship, not in lordship India since 5/4/2026, lordship. At that time of incident, he was not even in Hosai, not in Assam, even in India, lordship. That civil ID number I have already shown, lordship. That is the money receipt also on the day of occurrence also he purchased something in Kuwait, lordship, and he sent the money receipt, lordship, and I have annexed it. Page lordship 14. That is the date of incident itself, lordship. Page 14.
Okay, we'll see that.
Obliged.
PD was called for, my lord. That's not received, my lord. Otherwise, my lord, service completed, my lord. And my
Service
lord,
complete, but CD not received.
my lord.
Huh?
My lord.
My lord, actually, I mean, counsel for the respondent has been there. I mean, it is reflected in the cause list. So, I mean, service is completed.
Completed, my.
But
We
the
also
CD,
received, my lord, that report.
Last date also CD not received.
yes, my lord.
I'll learn it counsel for the PP. Service on respondent number 2 is name of counsel is also shown. The cause list. However, CD is not available. Run an additional PP to produce the CD on the next date fixed.
My lord, may I fix the matter on any date next week, my lord.
You know,
Obliged.
Obliged.
Yes. Received.
55 and 36, my lord, not received, my lord.
Sir, the information in this charge sheet submitted, Your Lordship.
This is submitted.
It's submitted, Your Lordship.
What is the offense? 103.
103 is there. Remove the family members, Your Lordship. Incident, Your Lordship, is
But we'll have the CTCR then.
36 regular bail in 86 days behind the bar. And
Charge sheet is submitted, so it is.
35, Your Lordship, 2 petitioners and Saddam Hussein, petition number 2, is not set for trial.
Third learned counsel for the petitioner submitted that CS has already been submitted.
Nine six.
Right, CS number 53 of 26, dated 9/6/26. And call for the scanned copy of the TCR list again on.
For date long. Oh, bless.
May I, Your Lordship? That should be FIR, Your Lordship will find at page 24. It's an FIR of 16/3/2024. Lordship, the
Yes, received.
Yes, my lord. CD received, my lord.
we have appeared before the investigating officer on 2nd of July, Lordship. The last occasion, Lordship, the interim was rejected. Against that, Lordship, the petitioner had approached the Honorable Apex Court and interim was granted to him. In terms of that, he had appeared before the IO and his statement was recorded on 2nd of July 2026. Those documents, Lordship, I've brought on record through the additional affidavit, Lordship.
We want additional affidavit to file.
We have filed an additional affidavit, Lordship, that is on record. The order of the Honorable Apex Court granting us interim and that we had appeared before the IO. Statements have been recorded, Lordship. Entirely a case based on documentary evidence, Lordship. And the specific allegation against.
Who are you actually? Who are you?
Lordship, I was the project director of the society at the relevant point of time. Now, Lordship, prior to lodging of this FIR on 16/2024, on 14/11/2022, I was relieved from that post. 1.5 years thereafter, this FIR was lodged. 2 years thereafter, Lordship, now I have been called for interrogation. The allegation.
Yes, PP.
Here, my lord, before going to the my lord facts, my lord, may kindly give a look to the my lord FIR, my lord. Kindly peruse the FIR. It is in page 24, my lord, typed copy, my lord.
Yes.
This is, my lord, the FIR, my lord. That is, my lord, lodged on, my lord, 16th of March 2024. And, my lord, here, my lord, in the second para of the FIR, my lord, it is a, my lord, gross anomalies, my lord. It is to be mentioned that rupees 10.94 crore was funded by agency franchised the development for procurement of vehicle under the Phase 2 Assam project on Forest and Biodiversity Conservation Society, ABC. Now, my lord, here, my lord, the present accused petitioner, who was the deed and, my lord, project director of that, my lord, APFBC, my lord. At that point of time, my lord, there, my lord, the notice inviting tender, my lord, that is, my lord, published, my lord, and the post, on the basis of that, my lord, NIT, my lord, they, my lord, procured some vehicle. Now, my lord, may kindly peruse the page 25, my lord, second part of the FIR, my lord.
So the documents, fictitious documents were submitted by him, by the SBL.
Not only, my lord, one time, my lord. And why, my lord, that my learned friend's submission is that, my lord, one, my lord, that is a matter is, my lord, he was released from the PD post in 2022. FIR is lodged on 2024. Now, my lord, 2026. That is his first contention, my lord. Now, my lord, secondly, my lord, on my lord, when the matter was, my lord, listed before this honorable court, my lord, definitely before the coordinate bench of this honorable court, my lord, at that point of time, my lord, his, my lord, prayer of interim prayer was rejected. Then thereafter, he approached the honorable apex court, my lord, on the point of that, my lord, the rejection of the prayer of the interim bail. And that was, my lord, he was, my lord, granted that interim protection. But my lord, learned Apex Court, my lord, or my lord, Honorable Apex Court, my lord may kindly see the affidavit which is filed by the, my lord, the accused petitioner. It is in page 67, my lord. Honorable Apex Court order, my lord. My lord may kindly peruse that, my lord. Page 67, my lord. My lord may kindly peruse the page 68, my lord. Page 67, my lord, in the, my lord, second para, my lord, the present salience in the special leave petition is to be rejection of an interim relief in an anticipatory bail application. Only that purpose, my lord. Now, my lord, in page 68, my lord, that is, my lord, para 3, my lord, learned counsel accept the notice on behalf of the respondent state of Assam. Let the counter affidavit be filed within a period of 4 weeks. Now, my lord, next two paragraphs, my lord. In the meantime, the petitioner shall not be arrested subject to the cooperation that he shall cooperate with the investigation. We further make it clear that the pendency of the special leave petition and the order passed by us will not stand in the way of the High Court proceeding with the main anticipatory bail application.
That far we
Yes,
understand. Now it's only a question of
Yes, my lord. I am coming to that.
material.
Why, my
evidence.
lord? Because, my lord, it is stated that, my lord, there is a long back, my lord. Now, my lord, in the FIR, my lord, in page 25, my lord, that is the, my lord, the second para of the, my lord. May I read, my lord? Only that particular para, my lord. MS so-and-so financial advisor was not present in the bid evaluation meeting. However, the PD so-and-so, that is the present accused petitioner, after completion of the evaluation informed that the AFD that she had not given the consent by email. The, my lord, first, the, my lord, that is the bidding procedure. That is, my lord, not, my lord, as per law, my lord. There, first the anomalies. Now, my lord, coming to the second part, my lord. That is the, from the same page, my lord, that is the second, third
My lord,
paragraph.
my learned friend, kindly read the whole paragraph. That is relevant.
That is
The second
relevant, obviously, my lord, because, my lord, that
whole
particular,
whole
that
paragraph,
particular
lordship.
person, my lord, I'm
The
going
whole
to read it
paragraph.
out, my lord.
Yes,
I'm going
please.
to read it out, my lord.
Please.
I'm not suppressing anything, my
Please.
lord. It is on record, my lord.
Please.
The email. Further, she had approved the payment, my lord. Further, she had approved the payment after delivery of the vehicles, and she was well aware about the tender process.
Therefore, this belies the
Yes,
contradiction.
sure. This is, my lord. That is the, my lord.
That belies the
Who is a
allegation,
government
lordship.
officer, my lord. That is the forest official, my lord. Present.
No, he's not a
petitioner-
forest official. He's a finance officer.
My lord, financial officer, all are, my lord, in the same nexus, and she is also one of the accused in the, my lord, FIR, my lord. Now, my lord, in the next part, my lord, that is the, my lord, last paragraph of the, my lord, the same page, my lord. That is the PDABC, namely KSP V Pavan Kumar, sought for additional documents from SBL Knowledge Services Private Limited on 30/4/2022. These documents were submitted by Sri Manoj Jacob, Vice President of SBL Knowledge Services Private Limited, with a forwarding letter dated 6/5/2022. There were discrepancies found in the date of documents. SBL Knowledge Services Private Limited had also submitted experience certificates from the State Bank of India and Nagaland Police as supporting documents of their experience and in supplying vehicles. However, SBI had not issued the experience certificate submitted by SBL Knowledge Services Private Limited, and it was suspected to be false. The work order and the completion certificate submitted by SBL Knowledge Services Private Limited in respect of Nagaland Police was also reported to be manufactured and fabricated documents. The Nagaland Police had in fact issued work order and completion certificate to the industrial firm, that is the other, my lord, bidder, and Equipment Private Limited instead. Now, my lord, they did this. The SBL Knowledge Services Private Limited had participated in the bidding process, knowing fully well that the experience was one of the preconditions for participations in the tender process and which they lacked. It is suspected that the SBL Knowledge Services Private Limited had resorted to forgery and submitted the fake fabricated documents to establish their experience in supply of vehicles. Now, my lord, the next paragraph, my lord. See, my lord, first, my lord, in the bidding process, my lord, that was not evaluated, my lord, as per law. The, my lord, that is the bidder, which is, my lord, was the eligible bidder in that process. Fake and fabricated document that was used. Now, my lord, the second part, my lord. It is the first part, my lord, initial. In the financial bid, SBL Knowledge Services Private Limited had submitted Performance bank guarantee. It is, my lord, very important, my lord. Entire the money trail, my lord, come from here, my lord, in this process, my lord. Performance bank guarantee PVC bearing number so and so of rupees 1 crore 9 lakhs 38,142 and 60 paisa only, issued by Northeast Small Finance Bank Limited, Silchar branch. The PVC was returned by AFBC. Now that was returned by, my lord, this, my lord, APFBC, and later destroyed by the bank. The, my lord, that is the PMU, APEBC accepted a new PVC issued by ICICI Bank from SBL Knowledge Services Private Limited. The developments surrounding the episode of PVC issued any SFB reported returning of this PVC, replacement of the first PVC by a fresh one, missing of the first PVC from the concerned file of the PMU, APFC, etc. Now, my lord, this is the, my lord, second part. Now, my lord, in the last paragraph, my lord, it is suspected that the SBL Knowledge Services Private Limited, in the conspiracy with the present accused petitioner, my lord, that is, his name is there, did and PD, other officers, along with other officers, my lord, staff of the project management unit PMU, APFBC vitiated the tender process not only by submitting false documents in its own bid documents, but also submitting serious bid. My lord, that is, my lord, the allegation. And in the FIR, my lord, what my learned friend has, my lord, pointed out, one, my lord, Momi Dihingia, my lord, she is also one of the accused, my lord. Now, my lord, police, my lord, from the, my lord, after, my lord, lodging of this FIR, my lord, they, my lord, one by one, my lord, because it is a, my lord, total, my lord, huge money trail, my lord. My lord, procurement of vehicles are there, different vehicles are procured, my lord, and a nexus is involved, and the present accused petitioner, who was the deed and PD, my lord, in this case, my lord. There, my lord, they have, my lord, collected, my lord, not only documentary evidences, but other witnesses also, my lord. What is a voluminous CD, my lord, from the last part, my lord. I have flag mark, my lord, that is, my lord, the relevant positions, my lord. Admittedly, my lord, after the, my lord, getting the, my lord, protection of the Honorable, my lord, Apex Court, my lord, he appeared, my lord. His statements recorded, some questions were, my lord, put, my lord, during, my lord, that is his, my lord, when statement were recorded, my lord can produce those statements also, my lord. And after that, my lord, police, my lord, filed one, my lord, bail objection, and, my lord, after that, my lord, that is statement, they, my lord, stated that, my lord, custodial interrogation is needed, my lord, in this case, my lord, as because, my lord, huge money trail is there, my lord, and, my lord, all the nexus is amongst the officers, my lord, and he is presently also, my lord, holding a post of, my lord, additional PCCF, my lord. Hope, my lord.
I mean,
So, my lord, every, my lord, possibilities are there, my lord, where, my lord, it can be manipulated, my lord. It is not that, my lord, he is not in that particular project from 2022, but that apprehension is always there. That is my lord, respectful submission before your lordship, my lord. And, my lord, I have flag marked, my lord, relevant part of the, my lord, CD.
Lordship, may I make my submissions? Kindly take up the FIR for a moment again. Page 24. The FIR, Lordship.
Yes.
Page 24 starts the second paragraph, which my learned friend had read out. It is to be mentioned that rupees 10.94 crore was funded by AFD for procurement of vehicles under phase 2 of so and so. And in this regard, NIT was advertised online in the newspapers. Now, your lordship will kindly turn over to the next page, page 25. What is the specific allegation against me? Ms. Momi Dihingia, AFS financial advisor, was not present in the bid evaluation meeting. However, APFBC, that is the present petitioner, after completion of the evaluation, informed AFD that she had given consent by email. That is the specific allegation against me. But Ms. Momi Dihingia denied being informed about the meeting and giving her consent to send any email. Now, the last line, Lordship, this is important. Further, she had approved the payment after delivery of vehicles and she was well aware of the tender process. Now, Lordship, the allegation against me that I had sent that email without consent stands belied by this last line, wherein the same incumbent who says that consent was not given had approved payment. And another aspect, Lordship, there is no allegation of any misappropriation of money. These vehicles which were procured were delivered and payments were approved. It's not a case that there were no delivery of vehicles. The only case is that, as the allegation is that, an ineligible bidder was declared to be eligible. Now, also the other bidders, which my learned friend had read out from the FIR, who had valid documents, they also never made any complaint that they were declared ineligible in a perverse manner. They had accepted the findings of the committee. They never challenged this award of contract to the SBL Knowledge Services. Now, as regards the other parts, Lordship, if your Lordship's permit, I will read through the entire affair. The allegation is that some fabricated documents were submitted by the bidder. Now, Lordship, a document, whether it is fabricated or not, can an officer with his naked eyes verify the same? If a document is fabricated, that can very well be a ground for cancellation of the bid. That is a different aspect. But these documents, these were approved by the bid evaluation committee, subsequently approved by the AFD, the funding agency. And only thereafter, Lordship, this work was awarded to the concerned bidder and the work was successfully completed. There is no dispute with regard to that. Now, Lordship, the third aspect, which my learned friend had relied upon, the cash trail. Page 26, your Lordship will see the third paragraph. Third paragraph, Lordship. Suspicious cash deposits were noticed in the bank account of Abdul Wahid Chaudhary, Senior Procurement Specialist APFBC, and his family members, which could not be satisfactorily explained by him. Now, this person was granted anticipatory bail by a coordinate bench of this Honorable Court in the year 2024. The person from whom there were suspicious cash deposits, right in 2024, Lordship, is still on anticipatory bail. They have not gone for any cancellation of their bail of any manner.
Where is that?
Lordship, I will just place that order, Lordship. He was granted interim protection, subsequently made absolute on Lordship 26/7/2024. The person from whom suspicious cash deposits were found. Now, Lordship, the last paragraph, page 26 of the affair. It is suspected that SBL Knowledge Services Private Limited, in conspiracy with the accused and other staff and project management unit, vitiated the tender process not only by submitting false documents in its own bid documents, but also by submitting spurious bid. Therefore, it is their own case in the affair that it's entirely a case based upon documentary evidence. And Lordship, another important aspect. FIR was launched in 2024. This notice was issued on 11/6/2026, Lordship. There is a gap of 2 years in between. Now, Lordship, what necessitated this sudden issuance of notice after 2 years is for the fact, Lordship, that 2024 it was issued. I was never called upon, no interrogation. My promotion, because I'm an IFS officer, Indian Forest Service officer, my promotion to the next higher post was denied, stating that FIR is lodged. Therefore, my promotion was denied, my junior was promoted. Lordship, that I approached the Honorable Central Administrative Tribunal. That order your Lordship will find. It starts from page that gave rise to this new incident now. Page 38, the order starts. Relevant is at Lordship, the final observation is at Lordship, page 54, wherein the promotion granted to my junior was set aside and I was directed to be promoted. The Honorable Tribunal held that the denial of promotion was wrong and I should be promoted. Now, this Lordship order got reported across various sections of the media, including the Assam Tribune. Lordship, in the Assam Tribune, this order was reported on 10th of June 2026. Page 55 is the typed copy. 10th of June, this order is published in the Assam Tribune. 11th June, they issue this notice. For 2.5 years, they do nothing. Now, this is only to frustrate the order of the Honorable Tribunal, because the moment I am arrested, your Lordship knows deemed suspension, that is a ground to stop my promotion again. So this FIR is being used by the authorities as a handle that whenever there is some order for your service benefits, we will use this FIR. 2.5 years, they do nothing. And ultimately, Lordship, it's entirely a case of documentary evidence. The FIR itself says that bank, admittedly, Lordship, let us admit for a moment, fraudulent bank guarantees, fraudulent experience certificates, these are all documents. Lordship, for documents, my custodial detention may not be necessary, and I've already appeared. And Lordship, my statement has been recorded, Lordship, only with regard to this documentary part, if I may rely upon a judgment, Lordship. May I place that, Lordship? Lordship, may I kindly see paragraph 18. Paragraph 18, Lordship.
Yes.
May I read it, Lordship? However, considering the nature of the allegations and the fact that the matter is to be investigated primarily based on documentary evidence, the court is inclined to grant the relief of anticipatory bail to the appellant. The offences alleged pertain to the exercise of administrative discretion in passing of an order rather than direct physical involvement. The prosecution has not demonstrated any necessity for the custodial interrogation of the appellant beyond scrutiny of official records, which can be done without placing him in detention. Additionally, the appellant has expressed his willingness to cooperate with the investigation, and no material has been placed before this court to suggest that he has evaded or obstructed the investigation in any manner. Furthermore, it is well settled that anticipatory bail can be granted where custodial interrogation is not essential, particularly in cases where the allegations hinge on official records and the presence of the accused can be secured without pre-trial detention. Now, Lordship, the FIR reflects that entirely it's a case based on documentary evidence. I have appeared, my statement has been recorded, and I am ready to appear whenever I am called for by the investigating officer. Lordship, and the person from whom suspicious cash deposits were found, he has been granted the privilege of anticipatory bail way back in 2024. My humble submission is that, Lordship, I stand on a far better footing than him. My only allegation is that I had sent an email. Lordship, that email is part of the record. They file a charge sheet tomorrow, that's a different aspect, Lordship. I will face trial. And there is no likelihood of my absconding, Lordship. And I was transferred as project director way back in 2022. 4 years, 1.5 years prior to lodging of the affair. My learned friend raised a contention that I am still holding the post of additional PCCL. Lordship, I am still in service. Person in service will hold some post. But as regards the society is concerned, he has been transferred way back in 2022. And the FIR reflects that every document is there with the investigating officer. Nothing stopped them to file a charge sheet till now.
Yes, PP, but see this 406 is there, 406, 409.
Yes, ma'am.
What has been entrusted and misappropriated?
My lord. My lord,
The
because
allegation, there is nothing.
my lord,
You know?
allegation, my lord, if my lord may kindly see, my lord. First, my lord, that is the my lord basic of the my lord BDs, my lord, that is illegal, my lord. Secondly, my lord, not only the illegal in the part of the my lord procurement or getting a my lord bid, my lord. The bidder thereafter, my lord, other allegations are there. Being a my lord, the government agency, my lord, they, my lord, there is the bank guarantee part, my lord. That money trial is also there. And it is a my lord whole nexus, my lord. It is not that, my lord, what my learned friend is stating on the first para, that is, my lord, in the evaluation committee, one email. Because in the evaluation committee, PD is a part, my lord. I have flag mark, my lord. Those part also, my lord. So because of that, my lord, to find out that nexus, my lord, because it is, my lord, the PC Act matter, my lord. In those act, my lord, being a my lord public servant, if my lord, they are not, my lord, have not that my lord nexus, my lord, it is not possible, my lord.
Which means that it is entirely based on suspicion, Lordship. What is?
And my lord, is a money trail, my lord. That is the story of my learned friend, my lord.
No.
And my lord, if my lord, that is my lord, from the lodging of the FIR, if my lord may kindly peruse the CD, my lord, from that onwards to 26, my lord, this is my gradually, my lord, that is my lord, the investigation is my lord progressing, my lord. Because they are, my lord, collecting some documents, even, my lord, they, my lord, send, my lord, what sort of, my lord, that is, my lord, that is the work, my lord, that is the what are the duties, my lord, entrusted upon the present accused petitioner. Those things are also there, my lord. But, my lord, all the things are not available in the note sheets, my lord. I leave it to your lordship, my lord. Otherwise, my lord, that money trail matter is there. False and fabricated way, my lord, undue advantage was, my lord, taken to give them, my lord. Thereafter, from a, my lord, government department, my lord, in a, my lord, project, my lord, that is the part of the bank guarantee, my lord, those parts are also there. And many people may come out, my lord, in this, my lord, in such type of investigations. Not only, my lord, the officials of the forest department, other, my lord, bank officials also, my lord. Two types of guarantee. One from, my lord, Northeast small finance, my lord, that is from there, that is, my lord, destroyed. Then thereafter from the ICICI, my lord. Those all things are, my lord, there, my lord. In those cases, my lord, where, my lord, money trail is there, my lord, it will sometimes take time. And when the, my lord, accused is a, my lord, high officials. So that is my respectful submission. Lordship, may kindly peruse the CD in this regard.
My only submission is that it's a case based on entirely documentary evidence. He has appeared, statement has been recorded, and the person from whom suspicious cash deposits were found granted anticipatory bail in 2024. And Lordship will kindly take note of the timing. 10 June it is done, 11 June this notice after 2.5 years. And it's entirely a case of documentary evidence. Will appear, Lordship, whenever the IO wants, Lordship, but custodial detention, with all due respect, Lordship, may not be necessary in the instance.
Monday, delivery of order.
Lordship, obliged, Lordship.
May I please, your lordship? Lordship, in this matter, lordship, POCSO Act was involved, lordship, and notice has been served. He is appearing on behalf of the respondent.
Counsel appeared, my lord, but my lord, CD not received, my lord, in this matter, my lord.
Well, objection, my lord, we may be given some time.
Lordship, the main contention in this matter was, lordship, that all the offences in this matter are punishable up to 7 years. And my instruction was that no any notice was served upon them under section 35(3), lordship, of the BNSS. And on the last occasion also, I prayed for some interim protection, but as the opposite party number 2 did not appear, so lordship, notice has been served. If some protection may be given in the meantime for the CD may be
We were given
reminder.
time to file objection, but kindly. Informant. Very serious offense has been released.
Lordship, if lordship peruse the CD also, lordship, the FIR, lordship, at page 10, lordship. Allegations do not attract as such the offences, lordship, only that they have been found in some 2 girls as seen, both of them going to the jungle, and their pants were half open. But to attract the allegations of section 8, lordship, there must be some contact, lordship. There is no such contact as such.
The allegation is of attempt,
Lordship,
basically.
lordship. Tim. And be-
As the objection, madam, with some, there's some accommodation.
Basic contention, lordship, that as because all the punishments are within 7 years, lordship, I was not served. That violation of section 35(3), lordship.
It's a POCSO, madam, that is to be. POCSO Act, that's why, madam, we are here.
Lordship, but in the POCSO section 8, the minimum punishment, maximum punishment is up to 5 years only, lordship. So, Ernest Kumar and this Satinder until a judgment will come up, lordship. It will be sheer violation of the section, lordship, 35(3), lordship. Yes, I may be protected till receipt of the CD, lordship.
Heard learned counsel for the petitioner. And he also heard still appearing for the CD as called for has not been received. Learned appearing for respondent number 2. Prays for some time to file objection. Petitioner submits that the offense is under section 8 of the POCSO Act, which is punishable by imprisonment up to 5 years only. And therefore, is under section 35 BNSS ought to have been issued to the petitioner as per direction of the Honorable Supreme Court in Ernest Kumar versus State of Bihar, 2014, 8 SCC 273. But the same has not been done, having regard to the nature of the allegations. Interim protection may be granted till receipt of the CD. There are perusal of the FIR and duration of the submission of counsel petitioner, provided that the next date fixed and until receipt of the CD, comma, the event of his arrest, the petitioner shall be released on interim bail. Security for like about provided that the petitioner try to influence or intimidate the witnesses. IO is directed to produce the CD. Next date fixed. List again on.
CD not received, my lord.
If I may be heard on interim minutes. The FIR is at page 14.
Is first date. We will wait till the when Monday. CD not receive, list again on Monday.
Much obliged.
This matter also, my lord, CD not received, my lord.
CD not receive, list again on
27.
Yes.
Item 18.
Item is over.
Item 18 itu কি video itu নহয় itu
who is appearing?
my lord.
Not in this item.
Forty already over. 40 রেপি হয়েছে
40 days on হয়েছে
40 রেপি হয়েছে
Yes.
my lord. Here from our office it is informed that my lord the report from the IO it was received only on 13/7 yesterday my lord. From that report it reveals that the case diary is lying in the office of the Honorable Chief Judicial Magistrate. That is one part my lord. And IO has paid for another date my lord.
That means search sheet is not filed, my lord.
My lord, and another aspect is that, my lord, from my limited understanding, my lord, from 8187, my lord, it was 118 subsection 2, my lord, it is 90 days offense, my lord, from my limited understanding, my lord. As it is the imprisonment for life is there, my lord. It is minimum or maximum, my lord. The case diary reveals, my lord, come under 118 subsection 4. But from the mere reading of the, my lord, 118 of subsection 2, my lord, for life, my lord, and Minimum is not 326 minutes, earlier 326 minutes plus 90 days offense minute.
If Rakeshpal is available with you.
Rakesh Pal says minimum has to be 10 years for 90 days, my lord. And is
That is what we are saying.
yes, my lord.
But here, my lord, I again read, my lord, whoever
No,
exceed-
that has been interpreted.
my lord. Here, but in the first part of the, my lord, section 1 it's subsection 2, my lord.
Same as 326.
It is clearly, my lord, my lord, it is-
167.
Right. It is clearly stated in.
167 has been interpreted earlier also in
Yes.
few other decisions. It has been interpreted. There was one dissenting judgment, but ultimately in Rakeshpal, I think it has been made clear. You just get hold of Rakeshpal, come back. When?
After tomorrow. After
Not already
No,
65
he
days, my lord.
he has exceeded the period
65
unless you
more
can
days.
satisfy us today itself. Come. What is the difficulty? Just press the fingers. It will come out. Ready for books, library for Just next item.
May I please, Your Worship? In earlier occasion, the Honorable Court is directed to take industry service in respect of respondent number 2. And so we are unable to, able to contact the petitioner, my lord. In this case, petitioner is convicted in a NI case, but we have filed it in 2024. Till then, service is not completed.
You cannot contact the petitioner.
Yes, madam, he is out of station. That's why we are unable to take the stay service. If possible, amicus may.
What is your prayer now?
Now, if allowed to take the stay service or otherwise,
You have already been allowed.
allow some time to take. We are unable to take stay.
Right, learned counsel for the petition. Further time to effect justice service prayer is allowed. Please take it on.
Yes, my lord.
Yeah, please, Your Worship. This is the appeal against conviction, my lord. NGPS matter, my lord. Objection has not been filed yet. Whatever.
Yes, pardon?
I'll provide copy to the learned PP, my lord, today. I did him, sir.
My learned friend will provide me a copy, my lord, today.
Right. Learned counsel for the petitioner to furnish copy of the petition IA to the learned additional PP in the course of the day. Thereafter, objection may be filed by
After 2 weeks, my lord.
prosecution within another 2 weeks. List again on.
My lord, deeply obliged.
Here also, my lord, service has been completed, my lord. On 26/5/2026, my lord, service has been complete. Service complete হয়েছে?
Service on respondent number 2 is lit, but none appears. So and so is appointed as amicus.
Here
This is-
also, my lord, we need to file objection, my lord. In this matter also, we need to file objection, my lord. 10 years, my lord.
I have already provided copy, my lord. I have already provided copy to the PP, my lord. In 2 days, they will file objection.
the Yes. Is taken on so and so. In the meantime. file
After a week.
objection.
1 week, after 1 week. Deeply obliged.
Mamta Bheri did. Karen Brown did. Agur what Asil Karnan did. P4 did no Agur. Yes.
What is it? Oh my God, obliged, my lord.
47.
May I please, your lords? This is your
Is
lordship.
this? IA.
IA is also there, your lordship, but the honorable court was pleased to fix it for final disposal.
Okay.
Already behind bar for 2 years, 26 days, 5 years conviction, your lordship. About half of the sentence, your lordship, to be completed.
So instead of IA, it was decided to take up the matter.
That is probably the, but I was kept pending, your lordship. The matter was fixed for hearing.
What do you want to do now? So IA or
Your lordship, 2 years has already been elapsed out of 5 years, your lordship. So on that ground, if your lordship can consider, your lordship, and the secondly, your lordship, the case, your lordship, there is some holes in the prosecution story, your lordship, which I will have to point out. I will have to go deep into the whole case, your lordship, in that case.
that is the purpose of a hearing.
Lordship, that is, it's up to your lordship. If your lordship ask me to, your lordship, argue on that, I will, and if your lordship decides to hear the IA, then also your lordship.
Yes, prosecution is prepared.
No, otherwise, till the minute file, for hearing, madam.
Mm-hmm.
Yes, fine.
Yes. All right.
Lordship. FIR, your lordship will get, your lordship. LCR is there, your lordship. Paper book has not been prepared, your lordship. FIR is dated 27/9/2023.
Let us do one doing. Let us see the first. Let's see the statement.
Lordship.
Evidence of the victim.
Lordship, that I will show your lordship, but just for a moment, your lordship, let me, your lordship, read the FIR for me. I will rely on that also, your lordship. FIR, your lordship,
মহোদয় বিনীত নিবেদন এই যে শিৱসাগৰৰ বেতবাৰী মৌজাৰ অন্তৰ্গত বাক্সু খেলুৱাই গাঁৱৰ নিবাসী মোৰ পুত্ৰীক 2728 নং কবৰ্ত প্ৰাথমিক বিদ্যালয়ৰ প্ৰধান শিক্ষক মহোদয়ে যৌন উৎপীড়ন কৰি শৰীৰৰ গোপ্তাংগত গভীৰভাৱে হাত দিয়ে। প্ৰধান শিক্ষকৰ নাম সোৱংশ ঘৰত লিখচন উপায়নাস্তিক হৈ মই চেৰেকাপাৰা আৰক্ষী চকীত অৱগত কৰিছো। দিছ ইজ দি এফআইআৰ ডেটেড 27/9/2023 and there is no date of place occurrence, your lordship, is mentioned, your lordship. Now your lordship may kindly come to the evidence of the PW2, your lordship. She is the may I read your lordship victims that
Yes. PW?
2, your lordship. ওচৰীয়া মোৰ দেউতা হয়, আছামী আমাৰ স্কুলৰ প্ৰধান শিক্ষক হয়। ঘটনা মোৰ লগত হয়, ছাৰে আমাক গণিত পঢ়ায়। ঘটনাৰ দিনা ছাৰে বৰ্ডত গণিত পঢ়াই আমাক বহীত লিখিবলৈ কৈছিল। তেওঁ মোৰ ওচৰলৈ আহি গণিত পঢ়িছোনে নাই চাই। মই হৰণ অংক ভালদৰে নাজানো বাবে তলমূৰ কৰি আছিলো। ছাৰে ওচৰলৈ আহি মোৰ পিঠিত ঢকিয়াব বিচৰাত মই পোন হৈ দিওঁ। ছাৰে মোৰ হাতেৰে পিটিকি দিয়ে, তেতিয়া মই পেচাব কৰিব লগা বুলি কৈ বাথৰুম যাওঁ। বাথৰুমৰ পৰা মন মাৰি ক্লাছলৈ উভতি অহাত লগৰ কেইজনীয়ে কি হৈছে বুলি সোধাত ছাৰে একো নাই হোৱা বুলি কয় আৰু মোক ঘৰলৈ যাবলৈ দিয়ে। সেই সময়ত স্কুল ছুটি আছিল। মোৰ লগৰ এজনীয়ে খিৰিকী মাৰি থাকোঁতে ছাৰে খিৰিকীখন অলপ ঠেলা মাৰি খুলি মই মন মাৰি থকা দেখি আজিৰ পৰা নকৰোঁলে যা বুলি মোক কয়। আমাৰ স্কুলত পঢ়া মোৰ ভণ্টিক ছাৰে মই অকলে
The entire evidence is in
Assamese.
Then paperwork ought to have been prepared. There are no translated copies otherwise. Directly to.
In fact, she says, your lordship, she disclosed about the incident to two of her co-student, your lordship. They have not corroborated that, your lordship, number one. Number two, your lordship, also what she has narrated, your lordship, is slightly different from the story narrated by the mother. Hardly, your lordship, that's my point, your lordship, that, your lordship, we have brought in about a previous dispute relating to a land between the family of the victim as well as the petitioner, appellant, your lordship. That aspect has completely brushed aside by the trial court, your lordship. And there are certain discrepancies in the Caesar list, which has also not been properly taken into consideration by the learned. And whether, your lordship, that will happen, one will dare to touch the student, your lordship, in presence of others, that also is a question, your lordship, that has bothered me, your lordship. If your lordship.
Yes, go on.
It may, otherwise, direction may be issued to the receipt for preparing the paper book or otherwise for translating those, my lord.
The translation is there in the impugned judgment actually.
Oh, lordship, judgment is. May I continue, your lordship? কি হৈছে বুলি সোধাত ছাৰে একো নাই হোৱা বুলি কয়, মোক ঘৰলৈ যাবলৈ দিয়ে। সেই সময়ত স্কুল ছুটি আছিল। মোৰ লগৰ এজনে খিৰিকী মাৰি থাকোঁতে ছাৰে খিৰিকীখন অলপ ঠেলা মাৰি খুলি মই মান মাৰি থকা দেখি আজিৰ পৰা নকৰোঁ দে যা বুলি মোক কয়। আমাৰ স্কুলতে পঢ়া মোৰ ভণ্টিক ছাৰে মই অকলে যোৱা দেখি মোৰ লগত যাবলৈ পঠিয়াই। মই ঘৰলৈ গৈ প্ৰথমতে মা আৰু আইতাক ঘটনাৰ বিষয়ে কওঁ। মা আৰু আইতাই পাপাক ঘটনাৰ বিষয়ে কয়। পিছত পাপাই আমাক থানালৈ কেছ দিবলৈ লৈ আহে। পুলিচে মোক সোধপোছ কৰে আৰু মেডিকেল কৰে। মোক পুলিচে কোৰ্টলৈ আনে, কোৰ্টত মই জবানবন্দী দিওঁ। Exhibit 5 is the statement recorded under section 164 CRPC. Exhibit P5123 are my signatures. ঘটনাৰ সময়ত মোৰ লগত একেখন বেঞ্চত ইদুস্মিতা দাস আৰু বিস্মিতা দাস বহিছিল। মই বাথৰুমলৈ অহাৰ পিছত মন মাৰি থকা দেখি ইহঁত দুজনীয়ে কি হ'ল বুলি সুধিছিল। মই কোৱাৰ আগতে ছাৰে একো নাই হোৱা বুলি কৈ আমাক যাবলৈ দিয়ে। পিছত সিহঁত দুজনে ৰাস্তাক মোক সোধাত মই সিহঁতক বুকু বিষোৱা বুলি কৈছিলে। ছাৰে মোক পিটিকি দিয়াত দুখ পাইছিলোঁ আৰু সেই বুকুখন বিষাইছে বুলি কৈছিলোঁ। দিছ ইজ এ ভেৰি স্পেচিফিক ষ্টেটমেণ্ট মেড বাই হাৰ্ট। ক্ৰছ এক্সামিনেশ্যন। আমাৰ পিছৰ বেঞ্চত ধ্ৰুপদ দাস আৰু হেমন্ত দাস বহিছিল। মই হৰণ অংক ভালদৰে নোৱাৰা বাবে বহীত অংকৰ উত্তৰটো কৰা নাছিলোঁ। ছাৰে ওচৰলৈ আহি অংকটো বুজাই দিছিল, কিন্তু যদিও মই কৰিব পৰা নাছিলোঁ। তেতিয়া ছাৰে খং কৰিছিল। ছাৰে খং কৰিলে ভয় লাগে। সত্য নহয় যে ছাৰে খং কৰাৰ বাবে ইদুস্মিতা দাস আৰু বিস্মিতা দাস, ধ্ৰুপদ দাস, হেমন্ত দাসৰ ওচৰত লাজ আৰু দুখ পাইছিলোঁ। সেই ঘৰত ছাৰৰ বিষয়ে মিছাই কৈছিলোঁ। সিহঁতেও অংক পৰা নাছিল। সত্য নহয় যে ছাৰে অংক নোৱাৰাৰ বাবে গালি পৰাৰ কাৰণে খং আৰু দুখত গৈ বাথৰুমত কান্দিছিলোঁ। সত্য নহয় যে মই মা আৰু আইতাক ছাৰে মোৰ লগত অভদ্ৰামি কৰা বুলি কৈছিলোঁ। সত্য নহয় যে পুলিচৰ আগৰ কোৰ্টত দেউতাই শিকাই দিয়া মতে কওঁ। সত্য নহয় যে ছাৰে অংক নোৱাৰাৰ বাবে মোক খং কৰাৰ কাৰণে মই মা, আইতা আৰু পাপাক মিছা ঘটনা কওঁ। ঘটনাৰ সময়ত বেলেগ শ্ৰেণী চলি আছিল। আমাৰ স্কুলত সৰ্বমুঠ 20 গৰাকী ছাত্ৰ ছাত্ৰী আছে, 2জন শিক্ষক। স্কুলৰ অংগনবাদী কেন্দ্ৰ আছে, তাত 2 গৰাকী বাইদেউ আছে। সত্য যে মই পুলিচৰ আগত ছাৰে ওচৰলৈ আহি পিঠিত ঢকিয়াব বিচাৰত মই পোনহৈ দিওঁ বুলি কোৱা নাছিলোঁ। সত্য নহয় যে ছাৰে পিটিকিয়াই মিছাকে কৈছোঁ। সত্য নহয় যে বাথৰুমৰ পৰা অহাৰ পিছত মন মাৰি থকা দেখি লগৰ দুজনীয়ে কি হ'ল বুলি সুধিছিল। মই কোৱাৰ আগতে ছাৰে একো কওঁ বুলি কৈ আমাক যাবলৈ দিয়ে বুলি মিছাকে কৈছোঁ। সত্য নহয় যে খিৰিকীখন খুলি মই মন মাৰি থকা দেখি আজিৰ পৰা নকৰোঁতে যা বুলি মোক কোৱা কথা পুলিচৰ আগত কোৱা নাছিলোঁ। সত্য যে আমাৰ স্কুলত পঢ়া ভণ্টিক ছাৰে মই অকলে যোৱা দেখি মোৰ লগত যাবলৈ দিয়া কথাটো পুলিচক কোৱা নাছিলোঁ। সত্য নহয় যে মোৰ লগত কোনো ঘটনা হোৱা নাছিল। সত্য নহয় যে পুলিচৰ আগত মোৰ লগৰ দুজনীয়ে ৰাস্তাত সোধাত ছাৰে পিটিকি দিয়া বুলি মই দুখ পোৱা বুলি আৰু সেই বুকু বিষাইছিল বুলি কোৱা নাছিলোঁ। সত্য নহয় যে বাথৰুম পিছত সত্য নহয় যে মোৰ দেউতাৰ লগত আছামীৰ মাটিৰ বন্দুকীৰ খোলাৰ কথালৈ মনোমালিন্য থকা বাবে মা দেউতাৰ কথা মতে আছামীৰ বিৰুদ্ধে সাক্ষী দিয়া নাছিল। Now your lordship will kindly come to the statement of the 2 PW5 and PW6. Same statement.
Yes.
May I read that? PW5. PW5 and 6, same statement they have given. 5 I am reading. ওচৰীয়াক চিনি পাওঁ। ভুক্তভোগী মনশ্ৰী দাসে মোৰ লগত একেখন স্কুলতে পঢ়ে। আমি একে গাঁৱৰে। আছামী আমাৰ স্কুলৰে প্ৰধান শিক্ষক হয়। আমাৰ শ্ৰেণীত 5 গৰাকী ছাত্ৰ ছাত্ৰী আছে। মই, মনশ্ৰী, বিস্মিতা, ধ্ৰুপদ আৰু হেমন্ত। আমাৰ বেঞ্চৰ মাজত মই বহোঁ। মনশ্ৰী মোৰ বাওঁফালে আৰু বিস্মিতা মোৰ সোঁফালে বহে। আমি প্ৰথম বেঞ্চত বহোঁ। ঘটনাৰ দিনা ছাৰে আমাক হৰণ অংক কৰিবলৈ দিছিল। আমি তলমূৰ কৰি অংক কৰি আছিলোঁ। মাজতে এবাৰ ছাৰে আহি অংক পাৰিছোনে নাই সোধে। আমি পৰা নাই বুলি কওঁ। অলপ পিছতে মনশ্ৰীয়ে বাহিৰত মুখ ধুবলৈ যায়। তাই অহাৰ সময়ত কান্দি কান্দি শ্ৰেণীলৈ আহে, ৰুমালেৰে মুখ মোচে। আমি কিয় কান্দিছ বুলি সোধাত তাই একো নক'লে। সেই সময়ত তাই নিজৰ ঠাইত কিতাপ বহি আছিল। পিছত স্কুল ছুটি হয়। আমি ঘৰলৈ অহাৰ সময়ত স্কুলৰ পৰা অলপ আঁতৰত অহাৰ পিছত মনশ্ৰীয়ে আৰু কান্দিবলৈ লয়। Now your lordship has seen, your lordship, that they have not even corroborated that she has asked Monosri about the victim about the why you are not doing maths. That has also not been corroborated, not to speak about touching her, your lordship. And the fact that she has disclosed it to them in the midst of the road while returning from the school, that has also not been corroborated by these 2 witnesses. And in the midst, in the first bench itself, they sit together and teacher will go there and will touch and they will not see it. That's probably not believable, your lordship. These are the 2. PW6 also makes the similar identical statement, your lordship. ঘটনাৰ দিনা ছাৰে আমাক হৰণ অংক কৰিবলৈ দিছিল। আমি তলমূৰ কৰি অংক কৰি আছিলোঁ। মাজতে এবাৰ আহি ছাৰে মোক অংক পাৰিছোনে নাই চাই অলপ পিছত মনশ্ৰীয়ে বাহিৰত ধুবলৈ যায়। তেওঁ টেপৰ পানীৰে মুখ ধুই ৰুমালেৰে চকু পানী মুচি শ্ৰেণীলৈ আহে। পিছত স্কুল ছুটি হয়। ছাৰে অংক নাচালে। ফুল ছুটিৰ পিছত মনশ্ৰীয়ে মন মাৰি আমাতকে আগবাঢ়ি আহে মই আৰু দৌৰি আহি সোধাত তাইক লগ ধৰো কি হৈছিল সোধাত তাই বুকুখন বিষাইছে বুলি কয় পুলিচে মোক সোধপোছ কৰে These are the statements. Now your lordship will kindly come to the statement of PW. PW3 your lordship. She developed this story a step further, your lordship. I have to what is it? PW4 your lordship may kindly. PW4. She is grandmother. Gusuri amur lora ভুক্তভোগী মনশ্ৰী দাস মোৰ নাতিনী হয় আছামীক চিনি পাওঁ আছামী মোৰ নাতিনী মনশ্ৰী দাস পঢ়া স্কুলৰ প্ৰধান শিক্ষক হয় মনশ্ৰী দাসৰ বয়স 11 বছৰ তাই 2013 চনৰ ছেপ্টেম্বৰ মাহত জন্ম হৈছিল ঘটনাৰ দিনা মই বোৱাৰী আৰু 3 বছৰীয়া সৰু নাতিনীজনী ঘৰতে আছিলোঁ সেই সময়ত নাতিনী মনশ্ৰী দাস স্কুলৰ পৰা কান্দি কান্দি ঘৰলৈ আহে মই তাইক কিয় কান্দিছে বুলি সোধাত তাই কয় ছাৰে তাইৰ পিটিকি দিয়ে লগতে কয় যে 3 দিনমান আগতে আছামীও তাই দিছিল তাইৰ বুকুৰ বিষ হৈছিল তাই ভয়তে আমাক কোৱা নাছিল কিন্তু ঘটনাৰ দিনা পুনৰবাৰ ইয়াত তাই কান্দি কান্দি আমাক সকলো কয় সেই সময়ত মোৰ ল'ৰা অৰ্থাৎ গুচৰীয়া বাহিৰত কেৰম খেলি আছিল মই কোৱাৰ আগতে মোৰ সৰু নাতি তনয়া দাসে দেউতাকক ঘটনাৰ বিষয়ে জনাইছিল যদিও তাই সৰু ছোৱালীৰ বাবে কথাষাৰত বেছি গুৰুত্ব দিয়া নাছিলোঁ পিছত মই কোৱাত সি লগে লগে খঙত আছামীক ফোন কৰে তেতিয়া আছামীয়ে হুলস্থুল নকৰিবলৈ কয় আৰু মেনেজ হৈ যাব বুলি কয় পিছত গাঁওবুঢ়া আৰু গাঁৱৰ অন্যান্য মানুহ আমাৰ ঘৰলৈ আহে তেওঁলোকৰ কথা মতে আমি থানাত এজাহাৰ দিওঁ পুলিচে মোক সোধপোছ কৰে নাতিনীয়ে ঘটনাৰ বিষয়ে কোৱাৰ পিছত আমি তাইৰ লগৰ ছোৱালী ইন্দুস্মিতা আৰু বিস্মিতা দাসক সোধাত সিহঁতি একো নাজানো বুলি কয় সত্য যে নাতিনীয়ে ঘটনাৰ বিষয়ে কোৱাৰ সময়ত আমাৰ সৰু নাতিনীজনী থকা বুলি পুলিচক কোৱা নাছিলোঁ সত্য যে মই কোৱাৰ আগতে সৰু নাতিনী তনয়াই দেউতাকক ঘটনাৰ বিষয়ে জনাইছিল যদিও তাই সৰু ছোৱালীৰ বাবে কথাষাৰত বেছি গুৰুত্ব দিয়া নাছিল বুলি পুলিচক কোৱা নাছিলোঁ সত্য নহয় যে মই তাইক কিয় কান্দিছে বুলি সোধাত তাই কয় যে ছাৰে তাই টিকি দিয়ে বুলি কোৱা কথাটো মিছাকে কৈছোঁ সত্য নহয় যে আছামীয়ে সত্য 3 দিন আগতেও তাই পিটিকি দিছিল বুলি কোৱা নাছিলোঁ সত্য নহয় যে ঘটনাৰ দিনা পুনৰবাৰ ছাৰে তাই দিয়া বুলি তাই কান্দি কান্দি আমাক সকলো কথা মিছাকে কৈছোঁ সত্য নহয় যে ঘটনাৰ দিনা মোৰ ছোৱালীয়ে অংক কৰিব নোৱাৰাত আছামীয়ে খং কৰিছিল তাই সেই আখেজতে আমাক মিছাকৈ ঘটনাত সাজাই গৈছে সত্য নহয় যে আমাৰ আছামীৰ লগত মাটিৰ বন্ধকী খোলাৰ কথা লৈ মনোমালিন্য থকাৰ বাবে আমি আছামীক বিৰুদ্ধে মিছা কেছ দিছোঁ নাও PW2 is mother your or PW1 is father your lordship. His cross-examination your lordship may kindly peruse. See, he has admitted about PW1 informant father.
Yes.
সত্য যে মই দিয়া এজাহাৰত ঘটনাৰ দিন বাৰ তাৰিখ উল্লেখ নাই সত্য যে ঘটনা ক'ত হৈছিল এজাহাৰত উল্লেখ নাই সত্য যে মোৰ ছোৱালীয়ে ঘটনা ক'ত আৰু কেতিয়া হৈছিল মোক কোৱা নাছিল সত্য নহয় যে মোৰ ছোৱালীয়ে আছামীয়ে যৌন উৎপীড়ন কৰি শৰীৰৰ ঊৰ্ধ্ব গুপ্তাংগত গভীৰভাৱে হাত দিয়ে বুলি কেছটো জটিল কৰিবলৈ এজাহাৰত মিছাকে লিখিছোঁ সত্য নহয় যে ছোৱালীয়ে আছামীয়ে তাইক যৌন উৎপীড়ন কৰি শৰীৰৰ গভীৰভাৱে হাত দিয়ে বুলি মোক কেতিয়াও কোৱা নাছিল সত্য নহয় যে মোৰ ছোৱালীয়ে বৰ্ডত দিয়া অংক কৰিছে নে নাই চাবলৈ আহি অংক কৰিব নোৱাৰাৰ বাবে আছামীয়ে তাইৰ লগৰ ছোৱালী দুজনী আৰু লগৰ ল'ৰা দুটাৰ আগত তাইক গালি দিয়াত তাই লাজতে কান্দি বাথৰুমলৈ গৈ মুখ ধুই আহে সত্য নহয় যে আছামীয়ে তাইৰ লগত একো বেয়া কাম কৰা নাই সত্য নহয় যে আছামীয়ে তাইৰ বুকুত পিনকি দিয়া নাই বুলি তাই কোৱা কথা মিছাকে কৈছোঁ আমাৰ গাঁৱৰ দেৱজিৎ দাসক চিনো তেওঁৰ পৰা 15,000 টকালৈ মাটি বন্ধকত দিয়ে মোক বন্ধকত দিয়াৰ আগতে উক্ত মাটি পাপু গগৈক বন্ধকত দিছিল 3-4 বছৰ আগতে উক্ত মাটিৰ বাবদ আছামীৰ পৰা টকা লৈ তেওঁক বন্ধকীত দিছিলোঁ আৰু উক্ত মাটিত বৰ্তমান আছামীয়ে খেতি কৰি আছে সত্য নহয় যে উক্ত বন্ধকী মাটি খোলাক লৈ মোৰ আৰু আছামীৰ মাজত মনোমালিন্য হৈছিল সেই আশাজতে মই এই মিছা গোচৰ আছামীৰ ওপৰত কৰিছোঁ That's a admitted fact that there is some dispute relating to the land that has been going on between them and your lordship will kindly see the one on independent witness they have examined and that is Nirova Deuri, PW7. ভুক্তভোগীক চিনি পাওঁ, তাই আমাৰ স্কুলৰ ছাত্ৰী, বৰ্তমান পঞ্চম শ্ৰেণীত পঢ়ি আছে। গুচৰীয়াক চিনো, আছামী আমাৰ স্কুলৰ প্ৰধান শিক্ষক। আমাৰ স্কুলত মুঠ 2জন শিক্ষক, মই সহকাৰী আৰু আছামী প্ৰধান শিক্ষক। আমাৰ স্কুল ঘৰটোত 2টা অংশ আছে, এটা অংশত ক শ্ৰেণীৰ পৰা 3য় শ্ৰেণীলৈ পাঠদান হয় আৰু আনটো অংশত 4ৰ্থ আৰু 5ম শ্ৰেণীৰ লগত স্কুলৰ অফিচ আছে। ঘটনাৰ দিনা স্কুলতে আছিলোঁ, ঘটনাৰ দিনা আছামীয়ে 4ৰ্থ আৰু 5ম শ্ৰেণী থকা অংশত পঢ়াই আছিল। ইন দি চেম room, your lordship, 2 part. মোৰ ঘৰ, মই আনটো অংশত পঢ়াই আছিলোঁ। মোৰ ঘৰ আছামীৰ ঘৰৰ ওচৰত। ঘটনাৰ দিনা গধূলি গুচৰীয়াই আছামীৰ ঘৰলৈ আহি পদূলিমুখত আছামীৰ পত্নীৰ লগত কিবা হুলস্থুল কৰি থকা শুনি আগবাঢ়ি যাওঁ, তেতিয়া গুচৰীয়াই মোক কয়, আছামীয়ে তেওঁৰ ছোৱালীক সেইদিনা স্কুলত বেয়া ব্যৱহাৰ কৰিছে। ইট ইজ দি ৱৰ্ড ইউজ দিছ বেয়া ব্যৱহাৰ। এণ্ড দেন মই তেওঁক কিয় ব্যৱহাৰ কৰিছে বুলি প্ৰশ্ন নকৰিলোঁ, কাৰণ তেওঁ মোক ঘটনাৰ বিষয়ে নাজানো বুলি কয় আৰু তাৰ পৰা যাব লাগিব। Till that moment, it is their own witness, says that he has said that he is not aware about the incident. পিছদিনা মই স্কুলত ভুক্তভোগী ছোৱালীজনীক কি হৈছে বোলে সিহঁতিও একো নাজানো বুলি কয়। পিছদিনা ভুক্তভোগী ছোৱালী অহা নাছিল। কেইদিনমান পিছত ভুক্তভোগী হয় আছামীয়ে ঘটনাৰ দিনা তাইক হাত দিছিল বুলি কয়। ভুক্তভোগীৰ মাক দেউতাকে মোক কৈছিল মানসিকভাৱে ডিষ্টাৰ্ব হৈ আছে, সেয়ে এণ্ড দেন ক্ৰছ এক্সামিনেশ্যন ইয়ৰ ঘটনাৰ বিষয়ে মই ব্যক্তিগত জ্ঞান নাই। সত্য যে মই পুলিচক কৈছিলোঁ ঘটনাৰ বিষয়ে মই অলপো অৱগত নহয় আৰু মনশ্ৰী এই বিষয়ে মোক একো কথা কোৱাও নাই। দেন লাষ্ট পাৰ্ট, সত্য যে মাটি বন্দুকীত থোৱা কথা লৈ আছামী আৰু গুচৰীয়াৰ মাজৰ সম্পৰ্ক ভাল নহয়। মোৰ মতে কোনো ঘটনা হোৱা নাই আৰু সেই ঘটনাৰ দিনা মই একো গম পোৱা নাছিলোঁ। This is the only independent witness they have examined. And PW10 is the IO. 27/9/2023 তাৰিখে মই চেৰেকাপাৰ আউটপোষ্ট আণ্ডাৰ শিৱসাগৰ থানাত IC হিচাপে কাৰ্যনিৰ্বাহ কৰি আছিলোঁ। সেইদিনা গুচৰীয়া বিশ্বজিৎ দাসে এখন এজাহাৰ দাখিল কৰে। উক্ত এজাহাৰখন মই GD এণ্ট্ৰি কৰি ৰেজিষ্টাৰ কৰাৰ বাবে শিৱসাগৰ থানালৈ পঠিয়াওঁ। পিছত থানাৰ প্ৰভাৰী বিষয়ে মোক তদন্তৰ দায়িত্ব প্ৰদান কৰে। মই GD এণ্ট্ৰি কৰি তদন্ত আৰম্ভ কৰোঁ আৰু গুচৰীয়াক থানাতে পাই তেওঁক সোধ-পোছ কৰোঁ। সেইদিনা ভুক্তভোগীক আৰু তেওঁৰ মাকক থানাত পাই তেওঁলোকৰ জবানবন্দী লিপি কৰোঁ। পিছদিনা ঘটনাস্থলী পৰিদৰ্শন কৰোঁ। ভুক্তভোগীৰ মেডিকেল কৰাই 164 CRPC জবানবন্দী গ্ৰহণৰ বাবে আদালতলৈ পঠাওঁ। এই ঘটনাস্থলীত অন্যান্য সাক্ষীৰ জবানবন্দী লওঁ, মানচিত্ৰ অংকন কৰোঁ। ঘটনাস্থলী 728 নং বাক্সু খেলুৱা কলিবৰ্ত LP স্কুলৰ 4ৰ্থ শ্ৰেণীৰ শ্ৰেণীকোঠা। ঘটনাস্থলীত ভুক্তভোগীৰ বান্ধৱী 2জনীক অনুপস্থিত পাই তেওঁলোকৰ ঘৰলৈ গৈ সোধ-পোছ কৰোঁ। 29/9/2023 তাৰিখে আছামী নিজে আহি শিৱসাগৰ থানাত হাজিৰ হয়। Your Lordship will kindly see my conduct is also an important part of it. I have never hesitated to face the ইনভেষ্টিগেশ্যন, ইয়ৰ লৰ্ডশ্বিপ। মই আছামীক কৰায়ত্ব কৰোঁ, সোধ-পোছ কৰোঁ। মই ভুক্তভোগীৰ জন্মৰ প্ৰমাণপত্ৰ জব্দ কৰোঁ। হস্পিটেলৰ পৰা ভুক্তভোগীৰ চিকিৎসাৰ প্ৰমাণপত্ৰ সংগ্ৰহ কৰোঁ। দেন ক্ৰছ, সত্য যে PW1এ মোৰ আগত দিয়া জবানবন্দীত তেওঁ ভুক্তভোগীক ঘটনাৰ বিষয়ে সোধাৰ সময়ত কান্দি থকা বুলি কোৱা নাছিল। লগতে তেওঁৰ পত্নীয়ে খং কৰিব বুলি ভয়তে কি হৈছে নোকোৱা কথা মোক কোৱা নাছিল। সত্য যে PW1এ মোৰ আগত কোৱা নাছিল যে মই ছাৰক ফোন কৰাৰ সময়ত আমাৰ মাজত হোৱা কথোপকথনখিনি ৰেকৰ্ডিং কৰি থৈছিলোঁ। উক্ত ৰেকৰ্ডিং মোৰ মোবাইল এটাৰ পৰা পেন ড্ৰাইভত আনি পুলিচক জমা দিছিলোঁ। উক্ত পেন ড্ৰাইভটো জব্দ কৰিছিল। সত্য যে PW2এ মোৰ আগত কোৱা নাছিল যে তাইৰ লগৰ এজনে খিৰিকী মাৰি থাকোঁতে ছাৰে খিৰিকীখন অলপ ঠেলা মাৰি খুলি তাইক মন মাৰি থকা দেখিছিল। সত্য যে PW2এ মোৰ আগত কোৱা নাছিল পিছত সিহঁত দুজনীয়ে ৰাস্তাক মই সোধাত সিহঁতক বুকু বিষোৱা বুলি কৈছিলোঁ আৰু ছাৰে পিটিকি দিয়াত দুখ পোৱা বুলি কৈছিলোঁ আৰু সেই বুকু বিষাইছিল বুলি কৈছিলোঁ। সত্য যে PW3এ মোৰ আগত কৈছিল যে তেওঁৰ ছোৱালীয়ে প্ৰথম খালি বুকুখন বিষোৱা বুলি তেওঁক কৈছিল, পিছত ঘটনাৰ বিষয়ে কয়। সত্য যে PW3এ মোৰ আগত কোৱা নাই যে তেতিয়া স্বামীয়ে আছামীক ফোন কৰে আৰু ঘটনাৰ বিষয়ে সোধাত ছাৰে স্বীকাৰ কৰে আৰু হুলস্থুল নকৰিবলৈ কয় আৰু মেনেজ হৈ যাব বুলি কয়। সত্য যে PW8এ মোৰ আগত কোৱা নাই যে তাইৰ লগত দুগৰাকী বান্ধৱীয়ে তেওঁলোকৰ মাক আমাৰ ঘৰত আছিল। পিছত বৌয়ে মোক কয় আসামীয়ে ভুক্তভোগীৰ স্কুলৰ শ্ৰেণীকোঠাত বুকুত হাত দিছে, সেই তাই কান্দি আছে। এতিয়া মই ভুক্তভোগীক সোধাত তাই মোক বৌয়ে কোৱা ধৰণৰ একে কথাকে কয়। আগতেও এদিন আসামীয়ে তাইৰ হাত দিয়া বুলি কয়। PWA-তে তেওঁৰ বৌয়েকে ভুক্তভোগীৰ লগত আসামীয়ে বেয়া কাম কৰা বুলি কয়। আগতেও দুবাৰমান এনেকুৱা কাম কয়। মই GD এন্ট্ৰি এক্সট্ৰা কপি আদালতত জমা দিয়া নাই, কিন্তু CDৰ লগত আছে। এজাহাৰখনত থকা তাৰিখৰ অভাৰ ৰাইটিঙৰ ওপৰত মই কোনো তদন্ত কৰা নাই। মই গাঁওবুঢ়া অথবা পঞ্চায়তৰ সদস্যৰ লগত গাঁৱৰ অন্যান্য মানুহৰ সাক্ষী গ্ৰহণ কৰা নাই। মই ভুক্তভোগীৰ লগত পঢ়া দ্ৰুপদ দাস আৰু হেমন্ত দাসৰ সাক্ষী গ্ৰহণ কৰা নাই। মই অংগনবাদী কেন্দ্ৰৰ দুগৰাকী বাইদেউৰ সাক্ষী গ্ৰহণ কৰা নাই। মই ভুক্তভোগীৰ স্কুলৰ অন্যান্য ছাত্ৰ ছাত্ৰীৰ সাক্ষী গ্ৰহণ কৰা নাই। মই ভুক্তভোগীৰ ভনীয়েক তনয়া দাসৰ সাক্ষী গ্ৰহণ কৰা নাই। ঘটনা 27/9/2023 তাৰিখে হয়। সত্য যে এক্সিবিট P3-ত 24/10/2023-ৰ পৰিৱৰ্তে 24/9/2023 বুলি উল্লেখ আছে। সত্য যে এক্সিবিট P3 মতে ঘটনাৰ আগতেই পেনড্ৰাইভ জব্দ জব্দ কৰা বুলি উল্লেখ কৰিছো। মই এই পেনড্ৰাইভটো FSLলৈ পঠোৱা নাই না। P3-ৰ Honorable kindly, Lordship will kindly see the P3. This itself clearly spelled out on the P3 to what is it? Whole story yours. Your Lordship will get it the second Caesar list, your Lordship. And he admitted, your Lordship. So, non-disclosure of the date in the affair assumes significance in view of this.
Where are you reading now?
Your Lordship, Caesar list of the pen drive. FIR is dated 27/9/2023. Pen drive
Yes, what does it say?
It says, your Lordship, date and time of Caesar is 24/9/2023 at 5:10 PM. The pen drive. The pen drive contains the recording between the
Is done.
24/9/2023, whereas the FIR is dated 27/9/2023. And your Lordship will find not only in one date, the date and time of Caesar on 24/9/2023 at 5:10 PM, then at the below seized by me, Omen SI, Purobi so-and-so, dated 24/9/2023. Now, non-disclosure of the date of occurrence in the FIR assumes significance. Some correction made in the Azahar, date of the Azahar, assumes significance in view of this. And a vital fact, so far as the date of occurrence is concerned, that cannot be left out by the informant, your Lordship. When this has happened, it is a very fundamental to the whole case, your Lordship, date of occurrence. It was subsequently they have developed this story. And the fact that these two students did not corroborate the story of the victim. In view of that, your Lordship, everything falls flat, your Lordship. The foundational facts that is required to be proved by them, that has not been able to, your Lordship. Ultimately, this is a stringent law, your Lordship. The standard of proof will also be higher when it comes to stringent laws, your Lordship. That is the settled principle of law, your Lordship. Now it has become in POCSO cases we have seen that relying on that Bhupen Kolite's judgment, The all courts, your lordship, without considering the defects either in the investigation, holes in the prosecution case, contradictions in the stories of the prosecution case, courts simply relying on the statement of the victim starts convicting accused persons, your lordship. And in many cases, therefore, your lordship, even innocent persons, your lordship, I am not saying all, in many cases, innocent persons also, yes. And this is a case, your lordship, in the class, there is other teacher teaching in the same room in a different class. Two students are there. They are not saying that I have asked the victim about anything. And it is, in fact, no reasonable man will do that, your lordship. And anyone having slightest of intelligence, your lordship, will dare to do that, your lordship. Had she been alone, then we can have some that yes, that may happen, but that is not the case. 4 other students are there, and 2 students are not brought on record by adducing their evidence. Just why they have not been, why Gauhati has not been examined. These are important witnesses to the entire story because their whole story is built upon that. The story is that the girl came, she told me, told mother and grandmother, grandmother and mother told father, father called him and recorded the telephonic conversation. Then also they went to the Gauhati. Now where is Gauhati to corroborate that? Rather the independent witness they have brought, she has denied, she has clearly said that nothing has happened. And when she went to the asking the mother of the victim, what has happened? She says that I don't know anything. You go. And the word specifically used is beya bebohar. Beya bebohar means what? Beya kam and beya bebohar. There are 2 separate phrases, your lordship. Had she said that beya kam, then matter would have been different. Beya bebohar means rebuking for not doing mathematics. And these contradiction has not even been considered by the learned court below, your lordship, learned trial court, your lordship. And without considering all this, the honorable court PW1 and PW7 both has admitted that there is an enmity between those 2 families, and that 2 land, and there is a possibility that can always happen. We need to, your lordship, keep suspicion, your lordship, only that. And if it doubt is creeps into the prosecution case, your lordship, matter ends there. And in my humble submission, your lordship, subject to what your lordship ultimately held, that from the narration of the facts, narration, the prosecution case, your lordship, this doubt is created by itself, your lordship. The discrepancies in the prosecution materials, discrepancies in the statements of the different witnesses, your lordship, and more importantly, admitted fact that there is a dispute between this man and the family of the victim. And ultimately, he has to suffer for 2 years, your lordship. He got. And your lordship will kindly see the judgments of the honorable court, your lordship. Para 22 onwards, the judgment is the finding of the court. How the till para 20, there is a record, the trial court recorded this, what the witnesses said, and para 22, your lordships may kindly come. May I read para 22, your lords? In this
I
state,
have already read half of it. Yes.
lordship.
So I've gone through it, yes, you can.
Lordship. Now, para 22, your Lordship will kindly see, the Honorable Court, Trial Court did not even discuss the differences of statement between the victim and the few witnesses. PW 5 and 6. Why? He can analyze, the trial court can analyze and reject it. That's a different matter altogether. But the trial court has not taken into consideration these contradictions, not even discussed. Para 22. Para 23, end of the no analysis, nothing. From the above evidence, it is found that the evidence of the victim and her statement under 164 CRPC is so consistent that there is no reason to disbelieve the victim or to deny the incident. The other PWs has deposed in the same line as deposed by the victim, rather accept the incriminating materials. The accused has admitted the circumstances, place of occurrence, presence of persons and other situation as presented by the prosecution. Based on that, your Lordship, conviction has been given. No one has, your Lordship, submitted that child witness is not a competent witness. Issue is whether her statement read with other statements, a statement of other witnesses and materials inspire confidence or not. That has to be discussed, your Lordship. And even if there are those contradictions, which learned trial court should have, probably in my humble submission, your Lordship, should have considered and then rejected, could have. That has also not been done. This clearly shows that with a predetermined approach, the entire judgment has been prepared, your Lords. And on the face of it, the predetermined approach of the learned judge is reflected, your Lordship. From up to 21, who said what? Then suddenly in 22, statement of the, regarding the statement of the victim, and 23, the learned trial court give a clear finding of guilt. Therefore, in my humble submission, your Lordship, my part is only to create doubt in the mind of the court, your Lordship. And in my humble submission, your Lordship, subject to what your Lordship held, that there is a clearly, on the base of preponderance of probability, that I have a defense. The defense I have set up is a good defense, and your Lordship, that has, and since your Lordship defense has been good, your Lordship, a preponderance, based on preponderance of probability, the appellant is required to be acquitted by this honorable court, your Lords. These discrepancies in the not even consider that this date of your Lordship seizing of pen drive is prior to lodging of the FIR, your Lordship. And this is a criminal case, your Lordship. One cannot say that this is a typographical error. That has also not been said. The IO rather says that yes, it is prior to the date of FIR. He has admitted, the investigating officer. After that, your Lordship, what remains in the case, your Lordship? It itself creates doubt. And therefore, in my humble submission, your Lordship, this case, the petitioner is required to be acquitted by this honorable court. Your Lordship, I have brought 2 or 3 judgments. Your Lordship can, without judgment also, your Lordship can definitely consider it. But one judgment is 2025 SSC Online Supreme Court 280, para 33, 34, 35. Your Lordship will go through, your Lordship. This is on the point, your Lordship, that omission of the material facts in the FIR brings the entire case of the prosecution under grave cloud of doubt. Para 33, 34, 35. And the fact that they have failed to, they have omitted to mention the date, your Lordship, of occurrence is a vital defect in this particular case, your Lordship. And this has enough to create doubt about the veracity of the prosecution case. Then another judgment, Your Lordship. This is also on that, Your Lordship. This is from live law. Para 27, Your Lordship. Para 27, Your Lordship. Same point. And third, Your Lordship, this is withholding of best evidence, Your Lordship, 27-28 para. Thomas Bruno and another. Here, Your Lordship.
This one is BN Johnny's para.
That is, Your
Second
Lordship, para 27. And this is para 27 and 28. This is on the withholding of evidence, Your Lordship. They have, in my case also, in this case also, they have withheld the evidence of the two students as well as the Gauhati, Your Lordship, with whom they have a discussion. This is my humble submission.
Yes.
My lord, I will not go into details of these evidences already. My lord, those statement evidences already pointed. I will just only like to point out some of the points raised by my learned senior regarding contradictions, my lord. Now here, this is a case of POSCO, my lord. Vital evidence here is, my lord, PW, that is, my lord, evidence of victim, PW2, and two of her friend, my lord, PW 5 and 6. And regarding, my lord, contradiction, that there is no, on that aspect, I will point out, my lord, regarding those contradictions and regarding, my lord, evidences, why evidences of the Gaubura and other two students who were present at that point of time in the school, because entire incident occurred in the classroom. And in that classroom on that particular day, along with the victim, there are other 4 students there, and 2 students evidences is there in, say, my lord, evidence of PW 5 and 6. And other 2 evidences, statement of the witnesses were not taken. And regarding the, during argument, my learned senior has stated that why the evidence of those 2 students and the state evidence of Gaubura were not taken. My lord, these are POSCO cases. My lord, in a POSCO case, in any other case, only the quality of evidence depends. Not it is required how many numbers of evidence will not required, my lord. While the case has been proved by the, my lord, vital evidence of the, my lord, victim and other evidences with, my lord, which also, my lord, corroborates, my lord, not only the evidence of her friends, my lord, other witnesses also corroborate the statement of the, my lord, victim. And, my lord, the victim, the age of the victim is, my lord, below 12 years, my lord. On that particular day, one incident occurred inside the classroom, my lord, and immediately, my lord, why she has not disclosed what happened to her, my lord, to the friends who were, my lord, cited as witnesses PW 5 and 6. At that point of time, she was crying. She immediately, my lord, after the incident, my lord, goes outside the classroom to, my lord, to bathroom, and thereafter, while she returned, my lord, then while her friends asked that what happened, how at that point of time a minor victim, my lord, can explain in detail. She was crying, my lord, natural, my lord. And how she can explain in detail to her friends, my lord, that what happened to her. Thereafter, immediately after the incident, she went to her house, immediately disclosed the incident to her mother, to her grandmother. Thereafter, my lord, her mother and grandmother disclosed the incident to her father. Then father immediately, my lord, contacted the accused. And regarding that, my lord, pen drive, what is that pen drive? Pen drive is the conversation between the informant and the, my lord, accused. And that, in that conversation, my lord, Caesar list, my lord, your lordship, my lord, that discrepancy in the entering in the date of that Caesar list, my lord, senior has pointed out. In fact, as though, my lord, regarding that explanation is there also by the accused, my lord, by the, my lord, witness, my lord. ঘটনা 27/9/2023 তাৰিখে হয় সত্য যে এক্সিবিট P3 24/10/23 পৰিৱৰ্তে 24/24/9/2023 বুলি উল্লেখ আছে. So, my lord, she has explained that, my lord, yes, immediately after the incident, my lord, on 24/10/23, my lord, the informant has handed over the pen drive to the IO, my lord, and how that can be a discrepancy. Otherwise, that evidence, my lord, can be said. He, in fact, my lord, in her evidence, my lord, explained in detail before that, while in my lord, other part of the evidence in the first part, he explained, my lord, he, my lord, specifically mentioned that on 24/10/23 তাৰিখে গুচৰিয়াই মোক এটা পেন ড্ৰাইভ জমা দিয়ে. So how that can be in a POSCO case, my lord, that discrepancy of the, my lord, that, my lord, in the Caesar list, that is pen drive, there is that is the conversation between the, my lord, informant and the accused person, my lord. In fact, my lord, that evidence is, my lord, not at all vital, because that evidence was not also sent to the FSL. Regarding, my lord, only on the basis of the only on the basis of the sole my lord, evidence of the PW2, my lord, victim, and, my lord, and her, my lord, the accused can be convicted, and her statement 164 statement, and her statement of, my lord, deposition before the, my lord, court, my lord, consistent, reliable. Where is the contradiction, my lord, of evidence of, my lord, victim, my lord? Where those contradictions were, my lord, pointed out to the IO, my lord? Regarding contradiction of other parts of the other evidences in some PW35 pointed by, where is the contradiction of the, my lord, victim was pointed out to the IO, my lord? These are the contradictions, my lord. These are the, my lord, discrepancies, my lord, that she has not disclosed all these things, my lord. And, my lord, so, my lord, prima facie, it seems that on the basis of the, my lord, in fact, all evidence of the PW2, my lord, there is nothing to disbelieve her, my lord, statement, because those evidences are corroborated by evidence of PW, her friends also, my lord, and other evidence witnesses also. And in fact, my lord, 313 statement of the accused also, my lord, in while, my lord, all these incriminating materials were pointed out by the learned court before him, my lord. In fact, all these circumstances that on that particular day this incident happened inside the classroom, he explained everything except that, my lord, that regarding that offense, my lord. So otherwise, my lord,
That is the only vital thing.
yes, my lord. That is the only vital thing.
Naturally, they are students, he is the teacher, they will be present in the classroom.
Yes, my lord.
What is the point of denying that?
Yes.
You will definitely admit to that.
I will admit that.
Otherwise, my lord, from the evidence of the, my lord, PW2 victim, my lord, and her 164 statement, my lord, there is nothing to disbelieve her statement, my lord, consistent, my lord, trustworthy, my lord. There is nothing to disbelieve her statement, and there is no contradiction even. And even if there is any contradiction, those contradictions were, my lord, not and minor contradiction, my lord, that can be, my lord, in a case of POSCO, my lord. Otherwise, my lord, foundational facts were, my lord, rightly established by the, my lord, prosecution, my lord. So they have not also, my lord, rebutted those evidence, those, my lord.
Yes.
And regarding, my lord, that, my lord, that land dispute, that there is some land dispute between the alia regarding mortgaging of land, only saying will not sufficient. They will have to prove by way of, my lord, placing evidence that there is some dispute for that.
That is admitted in cross-examination.
Why should I need to do
That part.
prove it?
But, my lord, only because there, yes, there is only because of that, my lord, that cannot be, my lord. Otherwise, from the statement of the PW2, only saying will, my lord, only that there's some dispute is there between the, my lord, victim and accused. That cannot be otherwise, my lord. Because of that, my lord, it cannot be said the entire case of the prosecution, my lord. While, my lord, regarding that aspect, no document, no evidence by the.
All right, merely because there may be some other dispute does not falsify the case.
Yes,
but
yes.
on the other hand,
Evidence of
it is an evidence of motive. That is all. Whether that motive was actually at play or not, that is a issue.
Yes, from the evidence of victim, well, PW2, and which was also corroborated by otherwise 164 statement, my lord, there is no infirmity in the order of the, my lord, in the judgment passed by the learned trial court. My lord, the learned trial court had rightly convicted the accused on the basis of the statement of the my lord, evidences of the victim, and those my lord, evidences of the victim are 164 found, my lord, consistent, my lord, and there is nothing to disbelieve.
Anybody for this private response?
I'm appearing for that comment.
Same argument.
CP has already submitted. The foundational facts has already been established by the prosecution. Birth certificate was seized and Lordship she was below 12 years. And the PW2 has already been very consistent in her 161, 164 and deposition. Other than that, Lordship, the entire incident has been corroborated by PW5 and 6, where her classmate. The only thing that because the headmaster, the accused also came near and to the near the victim and asked her, all those are corroborated, Lordship. That's my humble submission. Public.
Maybe.
Deep your pleasure.
There is no time for this. Call up.
May I please, Your Worship? The record is not available, my lord. Check, my lord, inadvertently record may not be called for.
Record call kora nai.
What do we say? That will be called for, my lord.
This is revision. Record is necessary.
My lord, revision, my lord. Two concurrent judgment, my lord. Two concurrent judgment by the record is necessary, my lord.
Heard learned counsel for the petitioner and it appears that the TCR has not been called for, or although the challenge is to the concurrent findings of the learned courts below. Hence call for the TCR. Again on. Yes, Mr. Biswas, when do you want?
My lord, last order, my lord, kindly peruse, my lord, below. There was the direction to ascertain whether the service is regarding service to ascertain whether it has been done or not. As per number 2, my lord.
Yes, any ascertainment has been made?
Nobody has entered appearance.
Don't know whether service has taken place or not. Whether you have taken fresh steps.
Myself, my lord, I have
Yes.
I have not taken fresh steps. I have not. I'll take steps, my lord.
That was there in the last order also.
I'll do, my lord.
Good. Learned counsel for the petitioner seeks further time to take steps on respondent number 2 as per previous order. Prayer is allowed. List the matter again after 4 weeks. Give a date.
In item 18, my lord, 60 days and 90 days, my lord. Or maybe pass, my lord, at this day.
I think it is. Yes, that is very much clear.
Yes, my lord.
Yes. Item
18. 1-8.
1-8, third learned counsel for the petitioner and learned additional PP. The petitioner was arrested on
11/5/26
and has now spent 65 days in custody. The alleged offense is under section 126 within bracket 2, 118 within bracket 2/3 within bracket 5 BNS. The statutory period of detention in respect of the aforesaid offenses is 60 days. View of the decision of the Honorable Apex Court in Rakesh Kumar Pal versus State of Assam 2017, 15 SCC 67. Accordingly, the learned additional PP submits that the case diary is lying with the court of the learned CJM Kamrup as per instructions received, which indicates that the charge sheet has not been submitted till date. Hence, the petitioner is entitled to default bail. Accordingly, it is directed that the petitioner shall be released on bail of rupees 20,000 with 2 securities of like amount to the satisfaction of the learned
CGM Kamrup Metro.
CJM Kamrup Metro. Petition stands allowed accordingly.
Deeply.
It will save it to